Mr. Young.
A quorum is not present.
The clerk will call the names of the absent senators.
The clerk will call the names of the absent senators.
Mr. Alexander, Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mr. Blumenthal, Mr. Blunt, Mr. Booker, Mr. Bozeman, Mr. Brown,
It's the people who are here.
Mr. Burr,
We'd never get anything done.
Ms. Cantwell, Mrs. Capito,
He knows you're.
Mr. Carden, Mr. Carper, Mr. Casey, Mr. Cassidy, Mr. Cochran, Ms. Collins, Mr. Coons, Mr. Corker, Ms. Cortez Masto, Mr. Cotton, Mr. Crapo, Mr. Cruz, Mr. Donnelly, Ms. Duckworth, Mr. Durbin, Mr. Enzi, Mrs. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Flake, Mr. Franken, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Heinrich, Ms. Heitkamp, Mr. Heller, Ms. Hirono, Mr. Hoven, Mr. Inhofe, Mr. Isaacson, Mr. Johnson, Mr. Kane, Mr. King, Mr. Langford, Mr. Leahy, Mr. Lee, Mr. Manchin, Mr. Markey, Mr. McCain, Mrs. McCaskill, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
A quorum is still not present.
I move to instruct the Sergeant at Arms to request the presence of absent senators and ask for the yeas and nays.
Is there a sufficient second? There is. Clerk, call the roll.
Mr. Alexander, Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mr. Blumenthal, Mr. Blunt, Mr. Booker, Mr. Bozeman, Mr. Brown, Mr. Burr, Ms. Cantwell, Mrs. Capito, Mr. Carden, Mr. Carper, Mr. Casey, Mr. Cassidy, Mr. Cochran, Ms. Collins, Mr. Coons, Mr. Corker, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Crapo, Mr. Cruz, Mr. Daines. Thank you. Mr. Donnelly, Ms. Duckworth, Mr. Durbin, Mr. Enzi, Mrs. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Flake, Mr. Franken, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hatch, Mr. Heinrich, Ms. Heitkamp, Mr. Heller, Ms. Hirono, Mr. Hoven, Mr. Inhofe, Mr. Isaacson, Mr. Johnson, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Lankford, Mr. Leahy. Thank you. Mr. Lee, Mr. Manchin, Mr. Markey, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young, Senators voting in the affirmative: Booker, Cantwell, Daines, Duckworth, Ernst, Fisher, Flake, Franken, Hassan, Heinrich, Kane, Klobuchar, Leahy, Nelson, Roberts, Rounds, and Wyden. Senators voting in the negative: Rubio, Toomey, and Wicker.
Well, it's a yes.
Ms. Warren, aye. Mr. Cochran, aye. Mr. Donnelly, aye. Mr. Tester, aye. Mr. Inhofe, aye. Mrs. Murray, aye. Ms. Cortez Masto, aye. Ms. Murkowski, aye. Mrs. Capito, aye. Mr. Corker, aye. Mr. Paul, aye. Mr. Scott, aye. Mr. Schumer, aye. Mr. Peters, aye. Mr. Reed, aye. Mr. Schatz, aye. Mr. Menendez, aye. Mr. Purdue? Aye. Mr. Grassley? Aye.
And then a subsequent quote. So these are two separate. I don't know if you can read on that. That's not in the minutes. It's down here.
All right, guys, if you guys just joined us, right now what they're voting on is the motion to
Aye.
instruct the Sergeant of Arms to request the attendance of those absent senators. Again, read the screen of what we're voting on right now. Read the screen,
Ms.
please.
Harris? Aye. Mr. Durbin? Aye. Mr. Casey? Aye. Mr. Gardner? Aye. Mr. Sullivan? Aye. Mrs. Shaheen? Aye. Mr. McConnell? Aye.
All right, for those that just joined us, please read the screen. This is a motion to instruct the Sergeant at Arms to request the attendance of absent senators. There's a lot of senators that are not showing up. So what's going to happen if this goes through?
Cassidy?
They're going to force
Aye.
those senators to report down to the floor. That's what's going on right now.
Mrs. Gillibrand? Aye. Mr. Manchin? Aye. Mr. Van Hollen? Aye. Mr. Udall? Aye. Mr. King? Aye. Mr. Bozeman? Aye. Mr. Burr? Aye. Mr. Langford? Aye. Mr. Barrasso? Aye. Ms. Stabenow? Aye. Mr. Young? Aye. Mr. Cardin? Aye. Mr. Moran? Mr. Blumenthal. Aye. Mr. Moran. Aye. Mr. Graham.
I'm with him.
Mr. Graham, aye. Mr. Johnson, aye. Mr. McCain, aye. Ms. Hirono, aye. Mr. Sass, aye. Mr. Shelby, aye. Ms. Heitkamp, aye. Mr. Alexander, aye. Ms. Baldwin, aye. Mr. Kennedy, aye. Mr. Blunt, aye. Mr. Lee, aye. Mr. Whitehouse, aye. Mr. Markey, aye. Mr. Thune, aye. Mr. Brown, aye. Mr. Merkley? Aye. Mr. Risch? Aye. Mr. Crapo? Aye. Mr. Cornyn? Aye. Mr. Hoven? Aye. Mr. Hatch? Aye. Mr. Bennett? Aye.
With the tiebreak.
In the affirmative, and the
Mr. Tillis? Aye. Mr. Cotton? Aye. Mr. Enzi? Aye. Mrs. McCaskill? Aye. Mr. Heller? Aye. Mr. Portman? Aye.
Are there any senators in the chamber wishing to vote or wishing to change their vote? If not, the ayes are 88, the nays are 3. The Sergeant at Arms is so instructed. A quorum is present. The question before the Senate. The question before the Senate is whether the decision of the chair to hold the senator from Massachusetts in violation of Rule 19 shall stand as the judgment of the Senate. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Mr. Alexander, Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mr. Blumenthal, Mr. Blunt, Mr. Booker, Mr. Bozeman, Mr. Brown, Mr. Burr, Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Mr. Cochran, Ms. Collins. Mr. Coons, Mr. Corker, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Crapo, Mr. Cruz, Mr. Daines, Mr. Donnelly, Ms. Duckworth, Mr. Durbin, Mr. Enzi, Mrs. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Flake, Mr. Franken, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hatch, Mr. Heinrich, Ms. Heitkamp, Mr. Heller, Ms. Hirono, Mr. Hoven, Mr. Inhofe.
Here, are we moving 88 to 0?
Mr. Isaacson. Mr. Johnson, Mr. Kane.
Yeah, thank you. Appreciate that. Thank you, got me. Yep. Yep. Thank you.
Mr. Kennedy.
Hey, Adam.
Mr. King. Ms. Klobuchar. Mr. Langford, Mr. Leahy, Mr. Lee, Mr. Manchin, Mr. Markey, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran. Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Nelson, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. Senators voting in the affirmative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Cochran, Corker, Cornyn, Cotton, Crapo, Daines, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Hatch, Johnson, Kennedy, Langford, Lee, McCain, McConnell, Moran, Paul, Perdue, Portman, Risch, Roberts, Rounds, Rubio, Sass, Scott, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, Young. Ms. Collins, aye. Senators voting in the negative: Bennett, Blumenthal, Booker, Brown, Cantwell, Cardin, Casey, Cortez Masto, Donnelly, Duckworth, Durbin, Franken, Gillibrand, Hassan, Heinrich, Heitkamp, Hirono, Kane, King, Klobuchar, Leahy, Manchin, Markey, McCaskill, Menendez, Merkley, Murphy, Murray, Nelson, Peters, Reed, Schatz, Shaheen, Stabenow, Tester, Van Hollen, Warren, Whitehouse, Wyden. Mr. Inhofe, aye. Mr. Hoven, aye. Ms. Murkowski, aye. Mr. Schumer, no. Mr. Grassley, aye. Mr. Udall, no. Ms. Harris, no. Mr. Heller, aye.
All right, for those that don't know what's going on, I guess one of the senators violated rule number 19, which means that they either spoke out of line or they interrupted another senator without their consent. So now they're trying to see how they're going to reprimand them, and that's what they're voting on, if they should reprimand them or they shouldn't. So that's what's going on right now.
Ms. Baldwin, no.
Take a second to consider subscribing to our channel. We encourage you that you do by clicking the subscribe button down below. Also, give this stream a thumbs up, and we will keep streaming until something happens, or they get a vote or whatever it is that continues to go on. Thank you very much for choosing Golden State Times as your stream of choice.
On this vote, the yeas are 49, the nays are 43. The decision of the chair stands as the judgment of the Senate. Democratic leader.
I yield 1 minute to the senator from Maine.
Mr. President,
Senator from Maine.
parliamentary inquiry.
After this back,
The senator will state his inquiry.
they responded.
In the opinion of the chair, would one senator calling another senator a liar during debate on the floor of the Senate be a violation of Rule 19?
In the opinion of the chair, it would.
Thank you, Mr. President. I yield back.
Mr. President.
Senate Majority Leader.
Expired. Senator Warren was giving a lengthy speech. She had appeared to violate the rule. She was warned. She was given an explanation. Nevertheless, she persisted. I yield the floor.
The senator from California.
Mr. President, the suggestion that reciting the words of the great Coretta Scott King would invoke Rule 19 and force Senator Warren to sit down and be silent is outrageous. I move that the senator from Massachusetts be permitted to proceed in order.
The question is on the motion.
Ask the yeas and nays.
Is there a sufficient second? There appears to be. Clerk will call the roll.
Mr. Alexander. Ms. Baldwin.
All right, folks, for those that are trying to figure out what's going on, Warren basically called Sessions a racist, bigot, Minuteman, and she went on and on and on. She had already been warned not to say those things about Sessions because they're not true, and she continued going on until one of the Republican senators had to come in and said that she violated Rule number 19, and they needed to vote on it, and that's what's going on as of right now. They pretty much told her to shut up and sit down. You violated that Rule number 19.
Mr. Bennett, Mr. Blumenthal, Mr. Blunt, Mr. Booker. Mr. Bozeman, Mr. Brown. Mr. Burr, Ms. Cantwell, Mrs. Capito, Mr. Carden, Mr. Carper, Mr. Casey. Mr. Cassidy, Mr. Cochran, Ms. Collins. Mr. Coons. Mr. Corker.
That's the judgment of the chair who calls you the majority leader.
About presiding information up there now. So get it or not.
Cortez Masto.
So the reason that this is an issue is because one senator cannot insult or lie about another senator while that senator is not present. So that is the reason why rule number 19 is being implemented on here.
Mr. Daines, Mr. Donnelly,
It's a quandary, but the rule doesn't
Ms. Duckworth,
nominees it's only about sitting senators.
Mr. Durbin, Mr. Enzi, Mrs. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Flake, Mr. Franken, Mr. Gardner,
I said if you don't mean it as a
Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hatch, Mr. Heinrich, Ms. Heitkamp, Mr. Heller, Ms. Hirono, Mr. Hoven, Mr. Inhofe, Mr. Isaacson, Mr. Johnson, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mr. Manchin, Mr. Markey, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. Senators voting in the affirmative: Baldwin, Bennett, Blumenthal, Booker, Brown, Cantwell, Cardin, Casey, Cortez Masto, Duckworth, Durbin, Franken, Gillibrand, Harris, Hassan, Heinrich, Heitkamp, Hirono, Kane, King, Klobuchar, Manchin, Markey, McCaskill, Menendez, Merkley, Murphy, Murray, Nelson, Peters, Reed, Schatz, Schumer, Shaheen, Tester, Udall, Van Hollen, Whitehouse, Wyden. Senators voting in the negative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Cochran, Collins, Corker, Cornyn, Cotton, Daines, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Grassley, Hatch, Heller, Hoeven, Inhofe, Isaacson, Johnson, Kennedy, Langford, Lee, McCain, McConnell, Moran, Murkowski, Paul, Perdue, Portman, Roberts, Rounds, Rubio, Scott, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, Young. Ms. Warren, aye. Ms. Stabenow, aye. Mr. Crapo, no. Mr. Risch, no. Mr. Donnelly. Mr. Donnelly, aye. Mr. Sass. Mr. Sass, no. Mr. Leahy. Mr. Leahy, aye.
On this motion, the yeas are 43, the nays are 50. The motion is not agreed to. The Democratic leader.
Mr. President, if the average American heard someone read a letter from Coretta Scott King, they would not be offended. They would say that's someone's opinion, that's all. It seems to me we could use Rule 19 almost every day on the floor of the Senate. This is selective enforcement and another example of our colleagues on the other side of the aisle escalating the partisanship and further decreasing comity in the Senate. I yield the floor.
Senator from Rhode Island.
Mr. President, I have a question. I guess it's in the nature of a parliamentary question, and that is whether it would be in order to ask unanimous consent that the letter from which Senator Warren read be put into the record as a confirmation that she was, in fact, accurately reading from the letter, that it be added as an exhibit in the congressional record.
The text of the letter is in the record of the Senate as the senator was reading it in her testimony.
The text of the letter as she read it, but not the complete letter.
The senator may ask consent.
May I ask unanimous consent that the complete letter from which Senator Warren read be made a part here of the congressional record to confirm that she has, in fact, read from it.
Objection is heard.
Mr. President.
Senator from Vermont.
Mr. President, this is fascinating. I'd say to my colleagues, I've served here longer than any member of this body. I've been here 42 years. I've been here when Democrats were in the majority and when the Republicans were in the majority. But Democratic presidents, Republican presidents, I never, ever saw a time when a member of the Senate who asked to put into the record a letter, especially by a civil rights icon, and somebody objected. It's always been done. I've had letters that have been, people have asked to put in that are contrary to the position I might take. Of course, I would not object. They're allowed to do that. I've seen letters when members on both sides of the aisle have debated back and forth, and the other side would put in letters that were contrary to their opponent's positions, and of course nobody objected. Don't let the Senate turn into something it's never been before. I would hope that cooler heads would prevail. And we go back to the things that made the Senate great, and made the Senate the conscience of the nation, as it should be. I have never once objected to a senator introducing a letter, even though it took a position different than mine. I've never known a Republican senator to do that. And here we're talking about a letter from a civil rights icon. Mr. President, let's not go down this path. It's not good for the country. It's not good for the United States Senate. It's not good for democracy. And it sure as heck is not good for free speech. I admire the senator from Rhode Island. He's a man of great integrity, man who is Attorney General of his state, U.S. Attorney in his state. His request was something normally accepted automatically. I would hope senators would reconsider. I yield the floor.
Mr. President.
Senator from Idaho.
Mr. President, I'm the one that entered the objection. And let me say to my good friend who just spoke, I agree with him 100% that we should get back to what made the Senate great. We have rules around here, and the rules are very clear that you don't impugn another senator. Now, you can't do that in your words, and you can't do it with writings. You can't hold up a writing that impugns another senator and say, well, this is what somebody else said. I'm not saying it, but that's okay. It is not okay. It is a violation of the rules, and we should get back to what made this Senate great, and that is staying within the rules, staying within civility, and not impugning another senator, whether it's through words or whether it's through writings. I yield the floor.
Senator from Florida.
I have a parliamentary. All right. The ruling of the chair was based on the advice of the parliamentarian. Is that accurate, Mr. Chairman, Mr. President? On the advice of the parliamentarian that the rule had been violated?
No. The chair sustained the ruling of the majority leader on his own.
Okay. The second question that I have, Mr. President, is the rule say that anything that impugns another member of the Senate directly or indirectly, is that an accurate reading of the rule?
Senator, you are correct, and I will read the paragraph. This is Rule 19, Section 2. No senator in debate shall, directly or indirectly, by any form of words impute to another senator or to other senators any conduct or motive unworthy or unbecoming a senator.
Thank you, Mr. President.
Mr. President,
Senator from Oregon.
a parliamentary inquiry.
State your question.
If a member of the Senate is being considered for nomination, and we're exercising our advice and consent power, and if there is factual conduct in that individual's background that is presented on the floor that is uncomplimentary, would presenting the facts of that conduct in the process of debating an individual be considered in violation of Rule 19?
The rules make no distinction between those senators who are nominees and those who are not.
And the rule does not permit truth.
And the rule does not permit truth to be evidence of a slight or to be a defense of a slight.
Mr. President, just to make sure I understand that clearly, if we are considering a nominee who happens to be a senator and we state factual elements of their background, for example, conviction of a crime that is inappropriate conduct in the past, stating the factual record about an individual would be considered in violation of Rule 19.
Each of these cases will be decided by the presiding officer in the context at that time.
Just to clarify, if I could, therefore, the point is that something can be absolutely true as perhaps a point that was made earlier. A statement can be true in a letter that is presented, but even if it's true and accurate for a person under consideration for nomination, it would still be in violation. In other words, the fact that an individual is found in violation of Rule 19 doesn't mean that the statement had to be false. It could have been a true statement. Thank you.
You are correct, Senator.
Thank you.
President.
The Assistant Republican Leader.
Mr. President, I just want the record to be abundantly clear. The language that resulted in the vote that we had invoking Rule 19 was related to a quotation from Senator Ted Kennedy that called the nominee a disgrace to the Justice Department, and he should withdraw his nomination and resign his position. That was the quote. Our colleagues want to try to make this all about Coretta Scott King, and it is not. I think the complete context should be part of the record.
Parliamentary inquiry.
Mr. President,
The Democratic Leader.
it's my understanding, I was not there, that there was a warning over Senator Kennedy's letter, but the actual ruling was based on Coretta Scott King's letter. Is that correct?
Yes.
Yes, that is correct.
Thank you, Mr. President.
Mr. President,
Senator from Rhode Island.
pursuing Senator Merkley's hypothetical, if it came before the Senate that a member of the Senate who was a nominee seeking the advice and consent of the Senate to the position was, for example, in fact, a horse thief, and we found the fact that he was a horse thief to be relevant to whether or not he should be confirmed, say, to the Department of Interior, which has authority over lands. Does the ruling of the chair mean that it would not be in order for the Senate or for senators to consider what in my hypothetical is the established fact that the senator was a horse thief as we debate his nomination here on the floor?
Once again, the answer is the same, that each of these decisions will be made at the time and in the context in which they occur, and the decision of the chair is subject to a vote of the Senate. And an appeal.
Well, I guess, Mr. President, what I don't understand is that we have fairly significant responsibilities under the Constitution to provide advice and consent. And it appears that the ruling of the chair has just said that when a member of this body is the subject of that advice and consent, then derogatory information about that person is not in order and is a violation of Rule 19 on the Senate floor. And with that being the ruling, I don't know how we go about doing our duties. Are we supposed to simply blind ourselves to derogatory information, discuss it privately in the cloakrooms, not bring it out onto the floor of the United States Senate, this supposedly great debating society that actually has a constitutional responsibility to discuss both the advantages and the deficits of a particular nominee?
In each case, it is the opinion of the President, subject to the final vote by the Senate to support or not to support the President's motion or the President's decision.
So the precedent going forward is that any senator who discusses derogatory information that is a matter of public record, that may even include criminal behavior by a senator who is a candidate for executive appointment that requires advice and consent, is at risk of being sanctioned by this body, by a simple partisan majority of this body, under Rule 19 if they raise those issues on the floor.
It is not necessary for a point of order to be raised under Rule 19, but if the point of order is raised, then an opinion will be made, and it is subject to a vote of the Senate. In the matter previously described.
Mr. President.
The Senator from Florida.
I have some comment, but let me first a parliamentary inquiry about these are the continuing rules of the Senate that have been in existence previous to this time and have carried over into this session. Is that correct?
The Senator is correct.
And the reason why I ask that, Mr. President, is the following. Look, I think we all feel very passionate about the issues before us. I have not been here as long as Senator Leahy, whose service here is quite distinguished in a long period of time. And I truly do understand the passions people bring to this body. I like to think that I, too, am passionate about the issues before us. And I think this is an important moment. It's late. I doubt very many people are paying attention. I wish they would, though, because I think what's at question here is perhaps one of the very reasons why I ran for this body to begin with. And maybe it's because of my background and where I'm surrounded by people that have lost freedoms in places where they're not allowed to speak. One of the great traditions of our nation is the ability to come forward and have debates. But the founders and the framers and those who established this institution and guided it for over 2 centuries understood that that debate was impossible if, in fact, the matters became of a personal nature. And let me begin by saying that I don't believe that that was necessarily the intention here, although that was perhaps the way it turned out. But I think it's important for us to understand why that matters so much. I want people to think about our politics here today in America, because I'm telling you guys, I don't know of a single nation in the history of the world that's been able to solve its problems when half the people in a country absolutely hate the other half people in that country. This is the most important country in the world. And this body cannot function if people are offending one another, and that's why those rules are in place. I was not here when Secretary Clinton was nominated as a member of this body at the time, but I can tell you that I am just barely old enough to know that some very nasty things have been written and said about Secretary Clinton. And I think the Senate should be very proud that during her nomination to be Secretary of State, despite the fact that I imagine many people were not excited about the fact that she would be Secretary of State, to my recollection, and perhaps I'm incorrect, not a single one of those horrible things that have been written or said about her, some of which actually did accuse her of wrongdoing, were ever uttered on the floor of the Senate. I happen to remember in 2004, when then Senator Kerry ran for president, Some pretty strong things were written and said about him. I was here for that vote when he was nominated and confirmed to be Secretary of State, and I don't recall a single statement being written into the record about the things that had been said about him. And I want everybody to understand at the end of the night, this is not a partisan issue. It really is not. I can tell you this with full confidence. If one of my colleagues on this side of the aisle had done that, I would like to think that I would have been one of the people objecting, and here's why. Turn on the news and watch these parliaments around the world where people throw chairs at each other and punches. And ask yourself, how does that make you feel about those countries? Doesn't give you a lot of confidence about those countries. Now, I'm not arguing that we're anywhere near that here tonight, but we're flirting with it. We're flirting with it in this body, and we are flirting with it in this country. We are becoming a society incapable of having debates anymore. In this country, if you watch the big policy debates that are going on in America, no one ever stops to say, I think you're wrong, I understand your point of view, I get it, you have some valid points, but let me tell you why I think my view is better. I don't hear that anymore. Here's what I hear almost automatically, and let me be fair, from both sides of these debates. Immediately, as soon as you offer an idea, the other side jumps and says, the reason why you say that is because you don't care about poor people, because you only care about rich people, because you're this or you're that or you're the other. And I'm just telling you guys, we are reaching a point in this republic where we're not going to be able to solve the simplest of issues because everyone is putting themselves in a corner where everyone hates everybody. Now, I don't pretend to say that I am not myself from time to time in heated debates outside of this forum, been guilty of perhaps hyperbole, and for those, I'm not proud of it. But I got to tell you, I think what's at stake here tonight and as we debate moving forward is not simply some rule, but the ability of the most important nation on earth to debate in a productive and respectful way the pressing issues before us. And I just hope we understand that because I have tremendous respect for the other chamber, and I understand that it was designed to be different. But one of the reasons why I chose to run for the Senate, and quite frankly to run for re-election, is because I believe that I serve with 99 other men and women who deeply love their country, who have different points of view, who represent men and women who have different views from the men and women that I may represent on a given issue, and who are here to advocate for their points of view and never impugning their motives. One of the things I take great pride in, I tell this to people all the time, is the one thing you learn about the Senate is whether you agree with them or not, you understand why every single one of those other 99 people are here. Because they're intelligent people, they're smart people, they're hardworking people, they believe in what they're saying, and they articulate it in a very passionate and effective way. And I understand when I see my colleagues stand up and say something I don't agree with, I try to tell myself, look, I don't understand why they stand for that, but I know why they're doing it, because they represent people who believe that. And I am so grateful that God has allowed me to be born and to live and to raise my family in a nation where people with such different points of view are able to debate those things in a way that doesn't lead to war, that doesn't lead to overthrows, that doesn't lead to violence. And you may take that for granted. I'm telling you that right now, all around the world tonight, there are people that if they stood up here and said the things that we say about the president or others in authority, you go to jail. And I'm not saying that's where we're headed as a nation. I'm just saying don't ever take that for granted. And the linchpin of that is this institution. The linchpin of that debate is the ability of this institution, through unlimited debate and the decorum necessary for that debate, to be able to conduct itself in that manner. And so I know that tonight was probably a made-for-TV moment for some people. This has nothing to do with censoring the words of some of the great heroes. I have extraordinary admiration for the men and women who led the civil rights effort in this country. And I am self-conscious enough or understanding to know that many of the things that have been possible for so many people in this country in the 21st century were made possible by the sacrifices and the work of those in that movement that came before us. This has to do with a fundamental reality, and that is that this body cannot carry out its work if it is not able to conduct debates in a way that is respectful of one another, especially those of us who are in this chamber together. And I also understand this, that if the Senate ceases to work, if we reach a point where this institution, given everything else that's going on in politics today where you are basically allowed to say just about anything, for I have seen over the last year and a half things said about people, about issues, about institutions in our republic that I never thought I would see, ever. Ever. If we lose this body's ability to conduct debate in a dignified manner, and I mean this with no disrespect towards anyone else, I don't believe anyone came on this floor here tonight saying I'm going to be disrespectful on purpose and turn this into a circus. But I'm just telling you that if this body loses the ability to have those sorts of debate, then where in this country is that going to happen? What other forum in this nation is that going to be possible? And so I would just hope everybody would stop and think about that. I know I've only been here 6 years, so I don't have a deep reservoir of Senate history to rely on. But I know this: if this body isn't capable of having those debates, there will be no place in this country where those debates can occur. And I think every single one of us, to our great shame, will live to regret it. Mr. President, I yield the floor.
Mr. President,
The Democratic leader.
I don't want to prolong this much more. I would just, in light of what my friend from Florida said, reread what I said earlier. If average Americans heard someone read a letter from Coretta Scott King that said what it said, they would not be offended. They would say that's someone's opinion. That's all. It seems to me we could use Rule 19 almost every day on the floor of the Senate, as my colleague from Maine so poignantly and piquantly exhibited a few minutes ago. This selective enforcement and another example of our colleagues on the other side of the aisle escalating the partisanship and further decreasing the comity of the Senate, which I treasure as well. This was unnecessary.
Mr. President.
From the senator from Utah.
Mr. President, I take umbrage with what the minority leader said. I sat here and listened to the distinguished senator from Massachusetts, who went on and on and on, and much of her remarks were criticizing a fellow colleague in the Senate. Now, I don't know about the other side, but I find it offensive for either side to be criticizing, as was done here tonight, a sitting member of the Senate. I'm absolutely astounded that the Democrats, my friends on the other side, have taken to the war tables the desire to defeat Jeff Sessions. I've been here a long time, and I have to say that I've known Jeff Sessions even before he came here, and I've known him since he's been here. And yes, I differ with him on a number of issues, but I would never say things about him like have been said by my colleagues on the other side. I would think that we ought to all take some stock of what we're doing here. Jeff Sessions is a very fine person. Think of his wife. She's a really fine person. Jeff has been here 20 years. He's interchanged with almost all of us. Sometimes you agree with him and sometimes you disagree with him. But he's always been a gentleman. He's always been kind and considerate of his colleagues. I can't name one time when he wasn't. And yet we're treating him like he's some terrible person who doesn't deserve to be chosen by the current President of the United States to be Attorney General of the United States. I think we ought to be ashamed of ourselves. I really do, on both sides. And frankly, we've got to get to where everything is not an issue here. I know some of my friends on the other side, and I've chatted, and they're not happy with the way this body is going. And with good reason. Everything doesn't have to lead to a gut fight on the floor. But that's where we're going. And frankly, there's an awful lot of politics being played here, sometimes on both sides. But to have, look, I happen to like the distinguished senator from Massachusetts. I think she's an intelligent, lovely woman in many ways. But I've got to tell you, I listened to her for quite a while, and she didn't have a good thing to say about a fellow senator here. And I frankly don't think that's right. If we don't respect each other, we're going down a very steep path to oblivion. I would hope that both sides that take stock of these debates, we can differ. We understand that the Democrats are not happy with the current president. We're happy with him. We can differ on that. And we can fight over various issues and so forth. But to attack a fellow senator without reservation seems to me the wrong thing to do. It may not have risen to the level of a violation of the rules, but I think it comes close. And I sat here and listened to most of it, and frankly, I don't believe that this distinguished senator from Massachusetts was right in any respect. I've been here a long time, and I've seen some pretty rough talk from time to time, but never like we've had these first couple of months here. And we've become so partisan on both sides that, we're almost dysfunctional. And I admit it was tough for the Democrats to lose the presidential election. Most people thought that Hillary Clinton would win. I was not one of them. I thought there was a real chance because I know a lot of people would not say for whom they were going to vote. And I think correctly interpreted that they were going to vote for Donald Trump. And the reason they were is because they're tired of what's going on. They're tired of what's hurting this country. They're tired of the picayune little fights that we have around here. I think we've got to grow up, and I suggest that all of us take stock of ourselves and see if we can treat each other with greater respect. But I've got to say, I resented, as much as I like the distinguished senator from Massachusetts, I resented the constant diatribe against a fellow senator. Even if everything she said was true, it wasn't the right thing to do. And I don't think any of us should do that to them either. We can differ, we can argue, we can fight over certain words and so forth, but I've been appalled at the way the Democrats have treated Jeff Sessions. And I found Jeff Sessions, having worked with him for 20 years, and have disagreed with him on a number of things, to be a gentleman in every respect, and to present his viewpoints in a reasonable and decent way. I would hope that my colleagues on the other side would consider voting for Jeff Sessions, or at least treating him with respect. Now, I admit that I think some of this comes from the fact that they're very upset at Donald Trump. And it's easy to see why. He won a very tough contested election against one of their principal people. And that's hard to take, maybe. But that doesn't justify what's been going on against Jeff Sessions. We ought to be proud that Jeff has a chance to become Attorney General of the United States. And he's going to be. That's the thing that really bothers me. Everybody on the other side knows that we have the votes to finally do this. And yet they're treating it as though this is a cause célèbre that they've got to try and win, which they're not going to win. And in the process, treating a fellow senator with disdain. It's wrong. And we'd all take stock of ourselves, and I'm not accusing my colleagues of not being sincere, but they've been sincerely wrong. And I'm personally fed up with it. Now, if we want to fight every day and just go after each other like people who just don't care about etiquette and courtesy, I guess we can do that. But I think it's the wrong thing to do. And I hope that all of us will stop, take note of what's been going on, and on both sides, start trying to work together. I know it was tough for my Democrat friends to lose the presidential election. I know that was tough. And they didn't think they were going to. And frankly, a lot of us didn't think they were going to. I did think that. But then again, I was one of 2 senators who supported Donald Trump. And in my opinion, with very, very good reason. I'm sure that doesn't convince any Democrats on the other side. But the fact is that we have to treat each other with respect, or this place is going to devolve into nothing but a jungle. And that would truly be a very, very bad thing. I'm not perfect, so I don't mean to act like I am, but I have to say that all of us need to take stock, need to start thinking about the people on the other side, need to start thinking about how we might bring each other together in the best interests of our country, and how we might literally elevate the Senate to the position that we all hope it will be. Madam President, I love all my colleagues. There isn't one person in this body that I don't care for and love. I disagree quite a bit with some of my colleagues on the other side, and even some of my colleagues on our side. But that doesn't mean that I have to treat them with disrespect. Madam President, I yield the floor.
Madam President.
Senator from Minnesota.
Madam President, I first wanted to say a few words about the Senator from Massachusetts and her passion and what she has brought to this chamber. And while I know she's not been allowed to complete her remarks today, I know that will not silence her, and we look forward to hearing from her tomorrow and many days in the future on so many topics. I also wanted to say something about my friend from Utah. We have worked together on so many bills. I've seen firsthand that he means what he says about treating this chamber with the dignity that we all deserve and the American people deserve. And also, I especially was impressed by the words from the senator from Florida. And when I see the leader and the Democratic leader over there talking in the corner now, I think that's a good sign because I have never seen a time where the Senate is more important, as the senator from Florida was mentioning. This is a moment in time where the Senate will not just be a check and balance, but it is also a place for compromise. And the one thing that I would differ slightly from my friend and colleague from Utah, this isn't just about Democrats responding with surprise or anger to the election of a new president. There have been a lot of things said in the last few months, calling judges so-called judges, some of the discussions and comparisons to foreign leaders, and things that we have heard from the White House in the last few weeks, the order that was issued that some of our Republican colleagues expressed a lot of concern about, that the Senate wasn't involved, that a lot of law enforcement people weren't involved. There have been reasons that people's passions are high, and there are reasons that are good ones because we care about this country. So I hope people will see that in perspective for why people are reacting the way they do. As for Senator Sessions, or the senator from Alabama, as I will call him for the purpose of these remarks, I am someone that has worked well with him. We have done bills together on adoption. We have worked together on trafficking, and I am proud of the work that I've done with him. We have also gone to the State of the Union together every single year, and I value his friendship. I came to the conclusion that I couldn't support him, not for those personal reasons, but because of some of the views that he's expressed in the past and his record, the Violence Against Women Act, his views on immigration, his views on issues relating to voting rights. And I think many of the colleagues, especially those that serve on the Judiciary Committee, feel the same way, that this wasn't personal, but we simply had a deep disagreement with some of his views on certain issues. Today, I thought I would focus on the voting rights issue. I spoke earlier about violence against women, and I think that's a good place to start as we work together going forward. We've seen an attack on Americans' election system, 17 intelligence agencies talking about the fact that a foreign country tried to influence our election. It is the core of our democracy. I know the senator from Florida himself has said this time it happened to one candidate, one party, and next time it could be another party, another candidate. And so this idea of voting, this idea of the freedom to vote is the core to our democracy. And one of the most important duties of the Justice Department, and that is the office for which the Attorney General would run, is safeguarding voters' access to the ballot box. This issue is important in my state. We have the highest voter turnout of any state in the country in this past election. And part of the reason we have such good turnout is we have good laws that allow for people to vote. It allows for same-day registration. We make it easy for people to vote. We don't make it hard. And for me, that is one of the major duties of the Justice Department, and that is to enforce our voting rights. I'll never forget when I traveled to Alabama in the last few years with one of the leaders, Congressman John Lewis, who is one of the 13 original Freedom Riders. In 1964, he coordinated the efforts for the Mississippi Freedom Summer, recruiting college students from around the country to join the movement to register African American voters across the South. People from my state people from every state in this chamber went down there for that march. On March 7th, 1965, Congressman Lewis and 600 other peaceful protesters attempted to march from Selma to Birmingham to protest violence against civil rights workers. As they reached the crest of the Edmund Pettus Bridge, they saw a line of troopers blocking their way. At the end of the bridge, those peaceful marchers were attacked just for calling for the right to vote. And John Lewis's skull was fractured, and he still bears that scar to this day. The weekend that I went back there, 48 years after that bloody Sunday, was the weekend that the police chief of Montgomery actually handed Congressman Lewis a badge and publicly apologized for what happened to him that day, 48 years later. But as moving as that apology was, we still have a duty to make sure that those sacrifices were not in vain. We also need to make it easier for people to actually vote. And that is a promise still unmet in America over 50 years later, whether it is lines at voting booths or whether it is laws in place that make it harder to vote. And I just look at this differently, having come from a high voter turnout state, a state where we have same-day registration. And when you look at the other high voter states that have that same-day registration, Iowa, the presiding officer state, is one of them. That is not really a democratic state, yet they have a high voter turnout, and people participate and feel a part of that process. New Hampshire, Vermont, the states are truly split, but what we want to see is that kind of participation. A couple of months after I was in Selma, the Supreme Court handed down its decision in the case of Shelby County versus Holder. In this decision, the justices found that a formula in Section 4 of the Voting Rights Act was unconstitutional. This formula was used to decide which states and localities needed to have federal approval for any changes made to their voting rights laws, endangering the progress made over the past 50 years. According to a report by the Brennan Center for Justice, following the Shelby County decision, 14 states put new voting restrictions in place that impacted the 2016 presidential election. 3 other states also passed restrictive voting measures, but those laws were blocked by the courts. So the harm is very real and very serious, and we can't sit by and just let this happen. Specifically, we need a Department of Justice that will vigorously enforce the remaining sections of the Voting Rights Act, as well as the National Voter Registration Act and the Help America Vote Act. Currently, a majority of the states are not complying with the National Voter Registration Act, leaving voting rolls outdated and preventing eligible voters from casting their ballots. Without a Department of Justice that makes the enforcement of these laws a priority, the rights of voters will continue to be infringed. Congress also needs to take action through legislation to make right what came out of that Supreme Court decision. Effectively throwing out the pre-clearance provision of the Voting Rights Act just doesn't make sense. As Justice Ginsburg put so well in her dissent, ending pre-clearance now is like throwing away your umbrella in a rainstorm because you're not getting wet. Those marchers in Selma sacrificed too much for us not to fight back. That's why I co-sponsored the legislation last Congress that would amend the Voting Rights Act. I'm under no illusion that amending the Voting Rights Act in Congress will be easy. It won't be. We have seen some bipartisan support. In fact, Congressman Sensenbrenner from my neighboring state of Wisconsin, who sponsored the reauthorization in 2006, called for Congress to restore the Voting Rights Act. As he put it, the Voting Rights Act is vital to America's commitment to never again permit racial prejudices in the electoral process. Another issue that I wanted to focus on this evening, which I raised in Senator Sessions' hearing, is the fundamental importance of freedom of the press. My dad was a newspaper reporter, and up until a few years ago, he was still writing a blog. So I'm especially sensitive to and concerned about maintaining the press's role as a watchdog. On a larger note, the role of journalists is critical to our nation's democracy. That's why our founders enshrined the freedom of the press in the First Amendment. And when I look at what we're seeing in the last few years in our country, what concerns me is this assault on democracy. You have these voting rights issues with people unable to vote, with lines, with restrictive voting laws passed as opposed to finding ways to allow more people to vote. You have the outside money in politics. You have recently some of the things being said about judges, and now you have some assault on this notion of the freedom of the press. Thomas Jefferson said that our first objective should be to leave open all avenues to truth. And the most effective way of doing that is through the freedom of press. This is still true today. Freedom of the press is the best avenue to truth. In fact, these values are more important now than ever, at a time when people are not exactly valuing the freedom of the press. I believe there are two distinct roles journalists will hold that Congress must preserve and strengthen in the coming years. The first is providing the people with information about their government. Sometimes this is as simple as covering the passage of a new law, a public forum. This work doesn't just lead to a better informed public, it also leads to important actions. Thanks to excellent reporting from across the country, Americans have been energized in the past. For instance, just a few weeks ago, when there was an attempt to gut the Office of Congressional Ethics over in the House. That came out, people were outraged, it was reported on, and they backed down. The second role we must preserve is journalists' responsibility to be fact-checkers. They research, they provide context, and when they need to, they correct. We need the newspapers and media to stand up for what's true and what's factual. Unlike what was recently said, not in this chamber, the press cannot simply keep its mouth shut. The American people deserve the truth, and we are all relying on journalists to keep digging for it. I take this personally and seriously. In Senator Sessions' hearing, I asked him whether he would follow the standards now in place at the Justice Department, which address when federal prosecutors can subpoena journalists or their records and serve to protect reporters engaged in news-gathering activities. The previous two attorney generals both pledged not to put reporters in jail if they were simply doing their job under the law. The senator from Alabama did not make that commitment, and when I asked him about this in his hearing, he said that he had not yet studied those rules. He also did not make a commitment when I later asked him to do that on the record. The senator from Alabama has also raised concerns in the past about protecting journalists from revealing their sources, including opposing the Free Flow of Information Act when it was considered by the Judiciary Committee in 2007, 2009, and 2013. So at this time, when our freedom of the press has been under attack at the highest level of government, I believe that it's critically important that our Justice Department continues to function as an independent voice that will protect the ability of journalists to do their job. Last, I want to take a moment to focus on the importance of the Antitrust Division at the Department of Justice. As ranking member of the Antitrust Subcommittee, I'm concerned about the state of competition in the marketplace. I'd like to just take a few minutes on this issue. I did ask Senator Sessions about this at his hearing, and he said he was committed to an independent division in the Justice Department and to continue that work without outside influence. I continue to believe that this issue will be important because of the massive amount of mergers we're seeing. The legal technicalities behind our antitrust laws will not be familiar to most Americans, but effective antitrust enforcement provides benefits we can all understand. When companies vigorously compete, they can offer consumers the lowest prices and the highest quality goods and services. Senator Sessions has stated that he will support the independence of that division, and I want to make clear how critical that is. It is absolutely essential that our next Attorney General enforces our antitrust laws fairly and vigorously, and that person protects the integrity of the Antitrust Division's prosecutorial function from inappropriate influence. This is because vigilant antitrust enforcement means more money in the pockets of American consumers. The Attorney General can do this by identifying and preventing competition problems before they occur, like stopping a merger that would allow a few dominant players to raise prices, or when a merger is allowed to move forward, putting conditions in place to protect competition. The next Attorney General will also be able to stop price-fixing cartels that hurt consumers by artificially inflating prices for goods such as auto parts, TVs, and tablet computers. Last year alone, the Justice Department obtained more than $1 billion in criminal antitrust fines. Anti-competitive practices have serious impacts on consumers. For example, pay-for-delay settlements that keep cheaper generic drugs from coming onto the market. Estimates suggest that limiting those sweetheart deals would generate over $2.9 billion in budget saving over 10 years and save American consumers billions on their prescription drug costs. That's why Senator Grassley and I worked on bipartisan legislation to give the Federal Trade Commission greater ability to block those anti-competitive agreements. Our Preserve Access to Affordable Generics Act would increase consumers' access to cost-saving generic drugs. The bottom line is this: antitrust enforcement is needed now as more than ever. We are experiencing a wave of concentration across industries. Just last year, then Assistant Attorney General for Antitrust Bill Baer, a lifelong antitrust practitioner, said his agency was reviewing deals with such serious antitrust concerns that they should never have made it out of the corporate boardroom. Not only will antitrust violations mean higher prices for Americans and less innovation, but the indirect effects are equally troubling. There is concern that undue concentration of economic power will exacerbate income inequality. There's also concern that concentration can hurt new businesses, stifling innovation. Why would you innovate if there's just one firm or two firms? Only effective antitrust enforcement by the Attorney General will prevent those harms. And effective enforcement can occur only if the Department of Justice makes enforcement decisions based on the merits of the individual case rather than politics. Traditionally, the White House has not interfered with antitrust enforcement decisions, but recent reports indicate that the president has discussed pending mergers with CEOs during ongoing antitrust reviews. Some companies have also publicly reported their conversations with and their commitments to the president. In both Senator Sessions' hearing and in a follow-up letter, I raised this issue from him. The senator from Alabama said it would be improper, this is a quote, to consider any political, personal, or other non-legal basis in reaching an enforcement decision. That is the correct answer. I plan to rigorously protect the Antitrust Division's prosecutorial integrity to make sure that antitrust enforcement is principled and it's done right. Antitrust and competition policy are not Republican or Democratic issues. A merger in the ag industry could have effect on farmers in Iowa, as the presiding officer knows. These are consumer issues, and these issues could not be more important to all Americans. We can all agree that robust competition is essential to our free market economy and critical to ensuring that consumers pay the best prices for what they need. I want to switch gears and conclude today by speaking about the President's executive order regarding refugees, especially those from Muslim countries, which has caused so much chaos across our country over the past several weeks. While I know that Senator Sessions was not involved in writing the executive order, it's very important that going forward, obviously, that the Attorney General and the Department of Justice's Office of Legal Counsel have a responsibility to review President executive orders and assure that the order is legal and that it is done right. I actually sent a letter with Senators Durbin, Whitehouse, Franken, Coons, and Blumenthal, and we asked Senator Sessions what he would have done if the President's executive order came across his desk. As a former prosecutor, I've long advocated for thorough vetting and have supported strong national security measures. I believe that the number one focus of government, the number one priority, should be making people safe. And while working to strengthen biometrics and other security measures is a good goal, this is not the way our government should work, that an order should be put out there without properly vetting it and figuring out the effect it would have. The effect it would have on a 4-year-old girl who's in a refugee camp in Uganda. That happened. In my state, a mom who had 2 children, a Somali mother, was in a refugee camp. She got permission to come over to our state and to our country as a refugee. But she was pregnant. And when she had that baby did not have permission to come with her. So she had a Sophie's choice. Does she leave the baby in the refugee camp with friends and go to America with her 2 other daughters, or do all of them stay in the refugee camp in Uganda? She made a decision that she would go with her 2 older girls, that would be the safest thing for them. For 4 years, she worked to get that child that was left behind in the refugee camp to America, to be reunited with her sisters. The baby was to get on a plane, who's now 4 years old, now a toddler, to get on a plane on the Monday after the President's executive order was issued. The 4-year-old could not get on that plane. Senator Franken and I got involved. We talked to General Kelly. He was more than generous with his time, and they made an exception, and the 4-year-old is now in Minnesota. But it should not take a senator's intervention, as many of my colleagues know that have worked on these cases, to get a 4-year-old who is supposed to be reunited with their family, something that our government had worked on for 4 years and Lutheran Social Services in Minnesota had worked on for 4 years. If Senator Sessions is in fact confirmed as the next Attorney General, these are actual issues that he's going to work on. And beyond that, we have the issue of how people in our country are afraid. We have 100,000 Somalis in Minnesota. We have the biggest Somali population in the country. A man who works for me started with my office 10 years ago. He's been our outreach to the Somali community. He was just elected to the school board. We have Somalis elected to our city council. They are part of the fabric of life in our state. Congressman Emmer, who actually took the seat held by Michelle Bachmann, is the co-chair, along with Congressman Ellison, of the Somali caucus in the House of Representatives. We have not seen this as a Democratic issue or a Republican issue in our state. We have welcomed these refugees. We have the second biggest population of Hmong in the United States of America. We have the biggest Oromo population. We have the biggest Liberian population. We have one of the biggest populations of people from Burma. We have 17 Fortune 500 companies in our state, Madam President, and when these refugees come over, they are legal workers, and they are a major part of our economy. So it is no surprise that during the last year, when we've heard the kind of rhetoric that we've heard, people have been concerned. Not just the refugees themselves, not just their friends and family, but a lot of people in our state. The churches have gotten involved, all kinds of every denomination in our state, to stand up for our Muslim population. Why? Because they've all heard the stories. One of my most memorable stories was from a family that I heard about when I was visiting with some of our Muslim population in Minneapolis. This was a story of two adults who actually had been in our state during 9/11. And during 9/11, George Bush stood up and he said, this isn't about a religion. This is about evil people that did evil things, but it is not to indict a religion. And his U.S. attorney at the time, the Republican U.S. attorney, went around with me, the elected prosecutor for the biggest county in our state, and we met with the Muslim population and assured them they were safe and told them to report hate crimes. And these two adults, they were there then. Nothing bad happened to them. No one called them a name. You fast forward to this summer, they're at a restaurant with their two little children. They're just sitting there having dinner. And a guy walks by and says, you four go home. You go home to where you came from. And the little girl looked up at her mom and she said, Mom, I don't want to go home and eat tonight. You said we could eat out tonight. The words of an innocent child. She didn't even know what that man was talking about because she only knows one home. And that home is our state. And that home is the United States of America. So if Senator Sessions is confirmed for this position, he is going to have an obligation to that little girl that was in that restaurant today and to all of the people in our country, because this is the Justice Department of the United States of America. And as a former prosecutor, I know a big part of that job is prosecuting cases and doing all we can to keep America safe from evildoers. But it is also about keeping our Constitution and our rights safe. Thank you, Madam President. I yield the floor.
Madam President.
Senator from Rhode Island.
Thank you, Madam President. The Attorney General of the United States holds a vital and also somewhat unique position in the federal government. The Attorney General of the United States is tasked with significant responsibilities that must be executed independently, sometimes even in defiance of the White House's wishes and interests. The Attorney General of the United States is tasked with enforcing our laws fairly, justly, and even-handedly, as well as with protecting the civil and constitutional rights of all Americans, of all persuasions, of all backgrounds. The Attorney General of the United States does not work for the President so much as for the people, and does not serve the administration so much as the law. I have served in the United States Department of Justice. I have felt its esprit de corps, its pride. And that pride is founded on a firm sense of the department's willingness to stand on what is right, even against the wishes of the White House. One fine example of this was Attorney General Ashcroft challenging and refusing to accede to the wishes of the White House on the Bush administration's warrantless wiretapping of Americans. The Department of Justice is well aware of the importance of its independence, and a successful Attorney General must be stalwart in protecting the department from political meddling by the administration or by Congress. We need only look back to Attorney General Gonzalez's resignation to recall how badly things turn out when an Attorney General yields to political pressure. An Attorney General also makes policy decisions about where and how to direct the department's $27 billion budget, and when and how to advise Congress to recommend new laws and modify existing policies. These are policy choices an Attorney General makes. It is no answer to questions about those policy choices to say, I will follow the law. That doesn't apply in this arena of funding decisions and legislative recommendations that are policy choices, not dictated by law. And those policy choices can have a profound effect on individuals, on communities, and on the fabric of our nations. Americans should be able to trust that their Attorney General will not only enforce the laws with integrity and impartiality, but stand up for Americans of all stripes and fight on behalf of their rights. That is the prism through which I evaluate Senator Sessions' nomination. I have known Senator Sessions for a decade and have enjoyed working with him on a number of pieces of legislation. However, the standard by which I evaluate an Attorney General nominee is whether Rhode Islanders will trust that in the tough clinches, he will be always independent and always fair. I have reviewed Senator Sessions' career as an attorney and as a senator, as well as his testimony before the Judiciary Committee. I have reflected on my own duties and experience as my state's Attorney General and as the United States Attorney in Rhode Island. I've also served as an attorney in our state Attorney General's office. And by the way, the Attorney General in Rhode Island has full prosecutive authority. Many states have a division in which the Attorney General has a narrow ambit of authority and district attorneys do the bulk of the criminal prosecution. Not so in Rhode Island. I've also had the occasion to listen closely to very strong and honest, serious concerns from Rhode Islanders who have made it plain to me that they fear what Senator Sessions would do as head of the Justice Department. For every constituent of mine who has expressed support of his nomination, 15 have expressed opposition. Senator Sessions has fought against fixing our immigration system, opposing, indeed, as the leading opponent of bipartisan legislation, which, had it passed, would have spared us much of the current debate over walls and immigration. Senator Sessions fought against our bipartisan criminal justice and sentencing reform bill. Senator Sessions opposed reauthorizing the Violence Against Women Act, a bill which is vitally important to the Rhode Island Department of Attorney General and to the domestic violence groups around Rhode Island. Senator Sessions' record on support of gay and lesbian Americans has alarmed many Rhode Islanders. Public statements and confirmation testimony by Senator Sessions suggest that he brings a religious preference to the department and that what he calls secular attorneys would be to him suspect compared to Christian attorneys. That distinction between a secular attorney and a religious attorney is one that runs counter to very solid principles upon which my state was founded. Roger Williams brought to us freedom of conscience. Senator Sessions has called Breitbart News a bright spot. I must disagree. Breitbart News is not to me a bright spot. Breitbart has published baseless and inflammatory articles with titles like "Birth Control Makes Women Unattractive and Crazy." In fairness, I should disclose that Senator Sessions' nomination carries an additional burden with me as the nominee of this president and this White House. The need for an independent attorney general has rarely, if ever, been greater. On the campaign trail, the American people witnessed Donald Trump glorify sexual misconduct, mock a disabled reporter, and make disparaging remarks about immigrants and minorities. We all witnessed chants at Trump rallies of "lock her up." At his confirmation hearing, Senator Sessions excused these as, and I quote him here, "humorously done." But in mass rallies that also featured people getting beaten and the press caged and vilified, this didn't seem very humorous to many Americans. I think Americans know that the good guys in the movie are not the ones in the mob. The good guy is the lawman who stands on the jailhouse porch and sends the mob home. That "lock her up" chant, to me, was un-American. And I believe across the country it made honest prosecutors' stomachs turn. Not surprisingly, many Americans are fearful of what the Trump administration will mean for them, for their families, and for their country. The problems with this president did not end with the campaign. President Trump and his family have brought more conflicts of interest to the White House than all other modern presidents and families combined. The proposed Trump domestic cabinet is an unprecedented swamp of conflicts of interest, failures of disclosure and divestment, and dark money secrets. We have not even been permitted in the course of our nomination, advice, and consent process to explore the full depths of that unprecedented swamp, because the dark money operations of nominees have been kept from us. And in one case, thousands of emails are still covered up. The Trump White House traffics in alternate facts, operates vindictively, and is a haven for special interest influence. None of this
is good. All of this suggests that there will be more or less constant occasion for investigation and even prosecution of this administration. Independence is at a premium. Nothing could have made this more clear than the first disagreement between the Trump White House and the Department of Justice, whose outcome was that the acting Attorney General, a woman of 30 years' experience in the department, a career prosecutor, former Assistant United States Attorney, former United States Attorney, and someone recognized for her leadership throughout the department, was summarily fired. This is also not a good sign. In recent history, Attorneys General Gonzalez, Meese, and Mitchell were politically close to their presidents, and the Gonzalez, Meese, and Mitchell tenures did not end well. Attorney General Mitchell worked for President Nixon. They met when their New York law firms merged in the early 1960s, and they became law partners. John Mitchell was the campaign manager for Nixon's 1968 presidential campaign. There were signs that things weren't quite right, because when Nixon nominated Mitchell to be his attorney general, he appealed directly to FBI Director Hoover not to conduct the usual background check. Mitchell ultimately resigned as attorney general in order to run President Nixon's re-election campaign. So the political link between Mitchell and Nixon was very close. And sure enough, scandal ensued. Attorney General Mitchell turned out to be a central figure of the Watergate scandal. As the chairman of the re-election committee, the famous creep, Mitchell was responsible for appointing G. Gordon Liddy and approving the Dirty Tricks program while still Attorney General. That Dirty Tricks program ultimately included breaking into Democratic National Headquarters in the Watergate. The upshot of this was that Mitchell was charged with conspiracy, obstruction of justice, and 3 counts of perjury. He was convicted on all counts, and he served 19 months in prison. Attorney General Edwin Meese was also very close to President Reagan. Meese joined the 1980 Reagan presidential campaign as chief of staff. He ran day-to-day campaign operations and was the senior issues advisor. After the election, Edwin Meese was given the job of leading the Reagan transition. And once in office, Reagan appointed Meese as counselor to the president. According to press accounts at the time, Meese was known as someone who, quote, has known the president so long and so well, he's become almost an alter ego of Ronald Reagan. That was the political background between Meese and President Reagan. Again, it did not end well. Meese came under scrutiny for his role in the Iran-Contra scandal. The congressional committee that reported on the Iran-Contra scandal in November 1987 determined that Meese had failed to take appropriate steps to prevent members of the administration from destroying critical evidence. An independent counsel named Lawrence Walsh finished a report in 1993 that stated that Meese had made a false statement when he said that Reagan had not known about the 1985 Iran-Contra deal. Iran-Contra was not the only controversy that plagued Attorney General Meese. A company called WedTech Corporation was seeking Department of Defense contracts in the early 1980s. The company hired Meese's former law school classmate and his personal attorney, a lawyer named E. Robert Wallach, to lobby the Reagan administration on its behalf. Attorney General Meese helped WedTech, at Wallach's urging, get a special hearing on a $32 million Army engine contract, although the Army considered the company unqualified. Well, the contract was awarded to WedTech, and then one of Meese's top deputies went to work for WedTech. The federal criminal investigation that resulted led to the conviction of E. Robert Wallach, the former law school classmate and personal attorney of Meese, for whom he had set up the meetings with the government. Independent counsel James McKay investigated the WedTech contract, including investigating allegations of misconduct by Meese. While Meese was never convicted, he resigned following the issuance of the independent counsel's 800-page report. Third is Attorney General Gonzalez. Attorney General Gonzalez was close to then Governor Bush in Texas. He was his general counsel. When Governor Bush became President Bush, Gonzalez came to Washington to serve as White House counsel. He was appointed Attorney General in 2005. During his tenure at the Department of Justice, there were multiple investigations, many of which played out before the Senate Judiciary Committee, involving the warrantless wiretapping program, the U.S. Attorney's scandal, and inquiries into the department's management of the torture program legal opinions. Ultimately, members of both houses of Congress called for Attorney General Gonzalez's resignation or demanded that he be fired by the president, and Attorney General Gonzalez resigned. There is a track record here of attorneys general who are politically close to a president coming in harm's way and doing poorly in the department. One particular office that is vulnerable to this kind of undue proximity and failure of independence is a body in the Department of Justice called the Office of Legal Counsel. Jack Goldsmith, a former head of the Office of Legal Counsel, and a Republican, by the way, testified before the Senate Judiciary Committee that, and I'll quote him here, more than any other institution inside the executive branch, OLC is supposed to provide detached, apolitical legal advice. And it has an honorable tradition of providing such advice to a remarkable degree. But under the Bush administration, the OLC departed from that tradition. It came up in a number of ways. The first was during our investigation into President Bush's warrantless wiretapping program, when Office of Legal Counsel memos supporting the program came to light. I plowed through a fat stack of those classified opinions that were held in secret over at the White House and pressed to have some of the statements declassified. Here are some of the statements that were declassified, found in those OLC opinions. I quote, "An executive order cannot limit a president. There is no constitutional requirement for a president to issue a new executive order whenever he wishes to depart from the terms of a previous executive order." So this means that a president could issue an executive order, have it published in the Federal Register, put it forward as the policy of the administration, a direction to all the attorneys in the administration, and then secretly depart from it without ever changing what the public is told about the policy. A theory like this allows the Federal Register, where these executive orders are assembled, to become a screen of falsehood behind which illegal programs can operate in violation of the very executive order that purports to control the executive branch. That was just one. Another one, I'll quote, "The president, exercising his constitutional authority under Article 2, can determine whether an action is a lawful exercise of the president's authority under Article 2. If that sounds a little bit like pulling yourself up by your own bootstraps, well, it sounds that way to me too. And it runs contrary to a fairly basic constitutional principle announced in the famous case of Marbury versus Madison, which every law student knows, which says it is emphatically the province and duty of the judiciary to say what the law is. A third example, and this is another quote from an OLC opinion, "The Department of Justice is bound by the president's legal opinions." Well, if that is true, what is the point of a president sending matters over to the Department of Justice for legal review? If the president did it and it's therefore automatically legal, there would be no function to the Department of Justice accomplishing that legal review. So in this area of warrantless wiretapping, the Office of Legal Counsel within the Department of Justice came up with what seemed to be quite remarkable theories in the privacy and secrecy of that office, in those classified opinions, that are really hard to justify in the broad light of day. That's why independence matters so much. Obviously, the White House wanted those opinions to say what they said, but in the clear light of day, they don't hold up. Let's move on from the warrantless wiretapping opinions of the Bush Department of Justice to the OLC opinions that the Bush administration used to authorize waterboarding of detainees. Again, I was one of the first senators to review the OLC opinions. And when I read them, I will say I was quite surprised. I was surprised not just by what they said, but by what they didn't say. One thing that was entirely omitted was the history of waterboarding. Waterboarding was used by the Spanish Inquisition, by the Khmer Rouge in Cambodia, by the French suppressing revolts in Algeria, by the Japanese in World War II, and by military dictatorships in Latin America. The technique, as we know, ordinarily involves strapping a captive in a reclining position, heels overhead, putting a cloth over his face, and pouring water over the cloth to create the impression of drowning. Senator John McCain, held captive for more than 5 years by the North Vietnamese, said this of waterboarding: "It is not a complicated procedure. It is torture." End quote. American prosecutors and American judges in military tribunals after World War II prosecuted Japanese soldiers for war crimes, for torture, on the evidence of their waterboarding American prisoners of war. None of that history appeared in the Office of Legal Counsel opinion. The other major thing the Office of Legal Counsel overlooked was a case involving a Texas sheriff who was prosecuted as a criminal for waterboarding prisoners in 1984. Let's start with the fact that this was a case that was brought by the Department of Justice. It was the United States Attorney for that district who prosecuted the sheriff. The Department of Justice won the case at trial, and the case went up on appeal to the United States Court of Appeals for the Fifth Circuit, the court one level below the United States Supreme Court. In its appellate decision, the United States Court of Appeals for the Fifth Circuit described the technique as, and I quote, "water torture." All a legal researcher had to do was to type the words water and torture into the legal search engines Lexis or Westlaw, and this case would come up. United States versus Lee. You can find it at 74 F. 2nd, 1124. Over and over in that published appellate opinion by the second highest level of court in the federal judiciary, they described the technique as torture. And yet, the Office of Legal Counsel never mentioned this case in their decision. Ordinarily, what a proper lawyer is supposed to do, if they find adverse precedent, i.e. decisions that appear to come down a different way than the argument that the lawyer is making, is that you report the decision to the court and then you try to distinguish it. You try to convince the judge you are before why that case was either wrongly decided or doesn't apply on the facts of your case. But the Office of Legal Counsel didn't offer any effort to distinguish the Fifth Circuit decision. It simply pretended it didn't exist, or it never found it. it's hard to know which is worse. At sentencing in the Lee case, the district judge admonished the former sheriff who had been found guilty of waterboarding. The operation down there would embarrass the dictator of a country. Well, it's also pretty embarrassing when what is supposed to be the institution inside the executive branch that is supposed to provide detached, apolitical, legal advice in an honorable tradition of providing such advice to a remarkable degree, to quote Professor Goldsmith, misses a case so clearly on point. That wasn't the only OLC error. In addition to the warrantless wiretapping statements, in addition to the Office of Legal Counsel opinions on waterboarding, they undertook a review of the Foreign Intelligence Surveillance Act. In the Foreign Intelligence Surveillance Act is something called an exclusivity provision. It says this: the Foreign Intelligence Surveillance Act, I quote, shall be the exclusive means by which electronic surveillance and the interception of domestic wire, oral, and electronic communications may be conducted. Shall be the exclusive means. Seems pretty clear, but the Office of Legal Counsel said about that language, I quote them here, unless Congress made a clear statement in the Foreign Intelligence Surveillance Act that it sought to restrict presidential authority to conduct wireless searches in the national security area, which it has not, then the statute must be construed to avoid such a reading. Which it has not? Congress said that this shall be the exclusive means. And if the OLC wasn't happy reading the language of the statute, they could go to a court where this language had already been construed. The decision was called United States versus Andonian, and the judge in that case ruled that this language, the exclusivity clause, I'm quoting the court's decision, reveals that Congress intended to sew up the perceived loopholes through which the president had been able to avoid the warrant requirement. The exclusivity clause makes it impossible for the president to opt out of the legislative scheme by retreating to his inherent executive sovereignty over foreign affairs. The exclusivity clause assures that the president cannot avoid Congress's limitations by resorting to inherent powers. So, in the face of that case law, the Office of Legal Counsel held that Congress hadn't said what it said, and this was not exclusive language, even though a court had said so. So the reason I share those three stories is because it really matters in important issues when the Department of Justice has the capability and the courage to stand up to the president. And it really matters when they get it wrong. It really matters when they say things that simply are not correct or legally sound in order to support a warrantless wiretapping program. It really matters when they don't find the case on point to evaluate whether waterboarding is torture. It really matters when they go around a clear congressional statute, which a judge has said closes the door to going around that statute by simply saying privately, well, that door is not actually closed. It matters. I have insufficient confidence that as Attorney General, Senator Sessions will be able to stand up to the kind of pressure we can expect this White House to bring. We know that this White House operates vindictively and likes to push people around. We found out recently that Mr. Bannon went running over to see General Kelly to tell him to undo the green card waiver of the Muslim ban. Thankfully, General Kelly refused and stuck by his duty. But this is the kind of White House we have, where they try to push people around to do the wrong thing. They're so contemptuous of authority outside their own that they're willing to attack a federal judge who disagrees with them, calling him a so-called judge. They're willing to fire an acting attorney general who disagrees with them, firing her summarily and accusing her of betrayal. The pressure that this White House can be expected to bring on the Department of Justice to conform itself not to the law, but to the political demands of the president is going to be intense. Moreover, the conflicts of interest that crawl through this White House and that crawl over this swamp cabinet offer every reasonable cause to believe that there will have to be investigations and prosecutions into this administration. That combination of a target-rich environment in this administration for investigation and prosecution with a vindictive White House that does not hesitate to try to bully officials into conformity calls for the highest degree of independence. And I don't feel Senator Sessions makes that standard. He was too close to the president during the political race. He has not stood up against any of these excesses that I have mentioned since then, and it is with regret that I must say I will not be able to vote to confirm him. One of the reasons I became a lawyer was because of To Kill a Mockingbird. As a kid, I just loved Atticus Finch. He's great in the movie. He's even better in the book. Some of the things that Atticus Finch says about the law and about human nature are so brave and so profound that from the first time I read that book, boy, I would have loved to have been Atticus Finch. Would have loved to have the chance to stand in the breach when everybody was against you and stick up for doing something that was right. Gosh, that felt so great. And like the scene in many movies, the hero is not a part of the mob, not carrying a torch toward the jailhouse. The hero is the lonely lawman who sits on the porch and won't let the mob in. That's what I think we are going to need in our next Attorney General. Mr. President, I yield the floor.
Mr. President.
Senator from Oregon.
Mr. President, I'll be speaking later tonight, perhaps about 2 o'clock, possibly on through 4 o'clock. But I wanted to take a few moments now and share some of the letter that was discussed earlier and share it in a fashion that is appropriate under our rules. And I'd like to thank very much my colleague from New Jersey for yielding a few minutes in order to do so. I think it's important for us to understand the context of what this letter was all about. This letter was a statement of Coretta Scott King, and it was dated Thursday, March 13th, 1986. And she noted that, and I quote now, "My long-standing commitment, which I shared with my husband, Martin," of course that's Martin Luther King, "to protect and enhance the rights of Black Americans, rights which include equal access to the democratic process, compels me to testify today." And then in her letter, she goes on to essentially present an essay about the essential role of voting rights in our country. And so I'll continue to read in that regard. She says, "The Voting Rights Act was, and still is, vitally important to the future of democracy in the United States. I was privileged to join Martin and many others during the Selma to Montgomery March for Voting Rights in 1965. Martin was particularly impressed by the determination to get the franchise of blacks in Selma and neighboring Perry County. As he wrote," now she's quoting Martin Luther King, quote, "Certainly no community in the history of the Negro struggle has responded with the enthusiasm of Selma and her neighboring town of Marion, where Birmingham depended largely upon students and unemployed adults to participate in nonviolent protests of the denial of the franchise. Selma has involved fully 10% of the Negro population in active demonstrations, and at least half the Negro population of Marion was arrested on one day." That was the end of the quote from her husband. She continued writing, "Martin was referring, of course, to a group that included the defendants recently prosecuted for assisting elderly and illiterate blacks to exercise that franchise." And each time she refers to franchise, she's referring to this fundamental right to vote under our Constitution. And she continued, "In fact, Martin anticipated from the depth of their commitment 20 years ago that a united political organization would remain in Perry County long after the other marchers had left. This organization, the Perry County Civic League, started by Mr. Turner, Mr. Hogue, and others, as Martin predicted, continued, quote, to direct the drive for votes and other rights." That's a quote from her husband. And then she continued in this letter. She says, "In the years since the Voting Rights Act was passed, Black Americans in Marion, Selma, and elsewhere have made important strides in their struggle to participate actively in the electoral process. The number of blacks registered to vote in key southern states has doubled," she said, "since 1965. This would not have been possible without the Voting Rights Act." She continues in her essay. She says, "However, blacks still fall far short of having equal participation in the electoral process, particularly in the South. Efforts continue to be made to deny blacks access to the polls, even where blacks constitute the majority of the voters. It has been a long uphill struggle to keep alive the vital legislation that protects the most fundamental right to vote. A person who has exhibited hostility to the enforcement of these laws, and thus to the exercise of those rights by black people, should not be elevated to the federal bench." She continues in her letter to note that 20 years ago, when we marched from Selma to Montgomery, the fear of voting was real, as the broken bones and bloody heads in Selma and Marion bore witness. As my husband wrote at the time, quote, "It was not just a sick imagination that conjured up the vision of a public official sworn to uphold the law, who forced an inhuman march upon hundreds of Negro children, who ordered the Reverend James Bevel to be chained to a sick bed, who clubbed a Negro woman registrant, who callously inflicted repeated brutalities and indignities upon nonviolent Negroes peacefully petitioning for their constitutional right to vote. Now, this is what he's referring to, what Martin Luther King is referring to, was to specific actions of sheriffs in the South who were representing the law. And then she continued, Coretta Scott King continued, free exercise of voting rights is so fundamental to American democracy that we cannot tolerate any form of infringement of those rights. Of all the groups who have been disenfranchised in our nation's history, none has struggled longer or suffered more in the attempt to win the vote than black citizens. No group has had access to the ballot box denied so persistently and intently. And she continued, over the past century, a broad array of schemes have been used in attempts to block the black vote. The range of techniques developed with the purpose of repressing black voting rights run the gamut from the straightforward application of brutality against black citizens who tried to vote to such legalized frauds as the grandfather clause, exclusions, and rigged literacy tests. Now, she proceeds to note that other techniques were used to intimidate black voters. And that included investigations into the absentee voting process. And this concerned her a great deal. And she notes that whites have been using the absentee process to their advantage for years without incident. Then, when blacks, realizing its strength, began to use it with success, criminal investigations were begun. And then she proceeds to address that there were occasions where individuals with legal authority chose to initiate cases specifically against African Americans while ignoring allegations of similar behavior by whites, choosing instead to chill, and now I'm quoting again, choosing instead to chill the exercise of the franchise by blacks through misguided investigation. Let me continue later in the letter, and she addresses her concern over a prosecution illegally withholding from the defense critical statements made by witnesses, and that witnesses who did testify were pressured and intimidated into submitting the, quote, correct, unquote, testimony, that is, incorrect testimony. Many elderly blacks were visited multiple times by the FBI, who then hauled them over 180 miles by bus to a grand jury in Mobile, where they could more easily have testified at a grand jury 20 miles away in Selma. These voters and others have announced they are now never going to vote again. And she obviously is addressing issue after issue that affected the black franchise, the franchise of African Americans, the ability to vote. And then she returns to her essay about how important this is. The exercise of the franchise is an essential means by which our citizens ensure that those who are governing will be responsible. My husband, she says, called it the number one civil right. Denial of the access to the ballot ultimately results in the denial of other fundamental rights. For it is only when the poor and disadvantaged are empowered that they are able to participate actively in the solutions to their own problems. Coretta Scott King continues, we still have a long way to go before we can say that minorities no longer need to be concerned about discrimination at the polls. Blacks, Hispanics, Native Americans, and Asian Americans are grossly underrepresented at every level of government in America. If we are going to make our timeless dream of justice through democracy a reality, we must take every possible step to ensure that the spirit and the intent of the Voting Rights Act of 1965 and the 15th Amendment of the Constitution is honored. She continued, The federal courts hold a unique position in our constitutional system, ensuring that minorities and other citizens without political power have a forum in which to vindicate their rights. Because of this unique role, it is essential that the people selected to be federal judges respect the basic tenets of our legal system: respect for individual rights and a commitment to equal justice for all. And then she goes on to say, the integrity of the courts, and thus the rights they protect, can only be maintained if citizens feel confident that those selected as judges will be able to judge with fairness others holding different views. And she concludes her letter, having examined a number of incidents in the historical record, with this conclusion, and I quote, "I do not believe Jefferson Sessions possesses the requisite judgment, competence, and sensitivity to the rights guaranteed by the federal civil rights laws to qualify for appointment to the federal district court." And that is the context of her letter, that voting rights matter a tremendous amount. And I applaud my colleague's efforts to make this point, my colleague from Massachusetts' effort to make this point and share this essay with you, the body of the Senate earlier this evening.
Would the Senator
Thank
yield
you.
for a question?
The Senator would.
May I ask the Senator through the chair if the letter from which he just read has a date?
The answer is that it does have a date, and that is Thursday, March 13th, 1986.
1986. And is the Senator aware of the occasion that brought this letter to the Senate?
I am.
What was that occasion?
That occasion was a hearing before the Senate Judiciary Committee regarding the potential appointment of the individual to the United States District Court of the Southern District of Alabama.
And this letter was made a matter of record in that hearing?
I do not know if it was made a matter of record. My impression initially was that she had read this letter at the hearing, but I'm not sure if it was presented in person or as a document submitted to the committee.
But clearly the content of this letter has been a matter known to the Senate and, depending on what the facts may show, may actually have been a record of the Senate for more than 30 years.
I believe that is probably correct.
So a senator of the United States has been accused of violating a rule of the Senate for restating to the Senate a phrase that has been a matter of record in the Senate, if indeed that is the case, for 30 years. I yield the floor.
Mr. President. Senator from New Jersey. Thank you, Mr. President. I rise this evening to continue the dialogue and conversation about the candidate, the nominee for Attorney General. I rise to join my colleagues in opposition to the nomination. I witnessed earlier tonight something that gravely disappointed to me. One of my colleagues, as was mentioned earlier, stood up to read into the record a letter that, as we've just saw, that has been a part of the record of this body for decades, to read that letter into the record. That was then stopped through the chair because it was said to impugn another sitting senator. As Chuck Schumer said, that is selective enforcement, but to me, there is that going on. and a lot more. I used to preside in the first months I was in the United States Senate and sat and listened to the speeches of many of my colleagues. I have to say, I am proud to be a member of the body where folks on both sides comport themselves with a level of comedy that is admirable. I heard some people tonight decry the descending of this body into unfortunate places, but the reality is my experience has been on the whole very positive. The respect and the collegiality here is something that makes this place incredibly valuable to work. And though the public might not see it, there are a lot of bills that get worked on together. Many of them get to the floor, many of them get votes, many of them get passed. I'm proud to have passed many of those bills with my colleagues that I don't just consider colleagues, frankly, I consider them friends. But within that context, I have to say, I have watched when I sat in the chair and had to listen to the floor, many times where people said things that made me feel that they were unfortunate. I've watched the President of the United States talked about his character, his motives, in ways that I thought were disparaging. But amidst all of this, I've never seen, in my 3 years, someone stopped from speaking on the Senate floor when, as the Democratic leader says so clearly, there could have been many other times where that rule was used. And that's a frustration to me. But what makes this more of a frustration is the context in which tonight it happened. You see, Senator Warren stood up and was speaking out with a passion about this nomination. And in the midst of her speaking her truth, in the midst of her speaking her heart, she was stopped as she read something into the record that had been there for decades. Now, to me, that's problematic, not just because it was a regular speech, but because this had to do with her constitutional duty of providing advice and consent. And she wasn't just quoting some thing that she heard on the street, some hearsay. She was actually quoting Coretta Scott King, a civil rights hero, the wife of the slain Martin Luther King, who we as Americans in our nation, we don't have many of them, literally recognize with a national holiday. And so in that, it makes it all the more disturbing to me that Senator Warren would stand up, exercising what is one of her specifically constitutional mandated duties, and was stopped because of a rule being enforced that, in my opinion, as well as the leader Schumer's, is selectively enforced. But let's go further to that. The contents of that letter, much of it which was shared, is actually substantive and has bearing on the thoughts and feelings of many people in the Senate. I was raised by a family who made it very clear to me something that I think it was Elie Wiesel said, that the opposite of love is not hate, it's silence. That is a profound sin to witness injustice, to see something wrong, and to simply be a bystander, to not speak up. What I respect about many of my colleagues, even those who I disagree, what I respect about Senator Warren is that they embody that tradition that I was taught by my parents, to speak truth to power, to speak truth even if your legs are shaking, even if your voice quivers, you speak truth. You do not be a bystander. You do not sit in indifference. You stand up and speak your truth. You do not let your soul be silenced. We are here as a country because at times of great moral injustice, people didn't remain silent. It is so important, this idea of speech in this country, that it was enshrined in the Constitution that we should have the freedom of speech. And yeah, it's not always comfortable to hear. I sat where the president, Senator from Alaska, is sitting, and there were many times I heard things that were uncomfortable, that I disagreed with, things that I thought were wrong. But this body of all bodies should respect this idea of free speech. I am proud tonight of Senator Warren. She stood and told her truth. And to see this body act as it did tonight is disappointing to me, and it is not a violation of the ideals of comedy. It's not. I heard great conversations from people I revere. Senator Hatch spoke tonight. He is a great man. I don't agree with him all the time. I think some of his ideas, I actually sometimes believe at the core that they're dangerous ideas. But I respect him. He and Teddy Kennedy, two men that argued with each other, sometimes with voices raised with a lack of comedy, they had a love for each other. And I was told by other senior senators when I first arrived that, yeah, give it all you got in debates. Argue and fight, but understand that at the end, we're all people that love our country. Nobody here is questioning Jeff Sessions' love of country. Nobody here is questioning his kindness and his collegiality. I experienced that. I'm 3 years in the Senate. He is far senior to me. And there's not a time that we connected on the floor or in the Senate gym in which he didn't show me kindness and respect. Let's put that aside. Heck, he and I even stood together and passed a resolution here in this body to give the Medal of Freedom to marchers across the Edmund Pettus Bridge. One of those marchers was John Lewis. But does that mean that if John Lewis believes strongly that to have Jeff Sessions ascend to the most powerful law enforcement office in the land, that he should remain silent? Does that mean that he should be quiet about that? No. In fact, John Lewis testified in the hearings in the Judiciary Committee against Jeff Sessions. Why? Because that's our tradition. And so I start my remarks tonight aggrieved by what I saw happen to Elizabeth Warren. In fact, it stunned me. I didn't even believe it when I heard it, that a United States senator would be silenced by another United States senator for reading something that has been in the record for 30 years, as if somehow we're afraid to hear that truth on that paper or in her heart. God bless her for standing up and speaking up and refusing to be silenced, and then in the traditions of the King family to take the consequences. I want you to know that what she did respects a difference that is worth analyzing for a moment. We have colleagues here that we disagree with. We're part of the United States Senate. And there is a lot of respect back and forth. Again, to center on the senior senator from Utah, he is a giant in my eyes, and the eulogy that he gave at Tenny Kennedy's funeral was one of my favorite United States Senate moments. Didn't happen on this floor, but it showed that two men who can fight and disagree can still have a love and respect for each other. Two men that could raise their voices at times, passionately arguing for what they believe in. This body was designed to bring people of diverse geographies, thank God, eventually diverse racial backgrounds, diverse in gender, to bring us all together representing our states and to have it out. And no one senator has supreme power. This is not the executive branch. We have to vote on things that has to meet a 50 vote or 60 vote threshold on most occasions. That's the type of power we have here. But when someone from here leaves this position and moves to the executive branch and is heading an agency, they have tremendous power. And in fact, the Attorney General is one of the most powerful positions in America, and actually even in some senses independent of the presidency. The idea of the Attorney General is that when the president is wrong, the Attorney General has a role in letting the president know that and taking the appropriate action. And so while Jeff Sessions is a valued colleague here as a senator ascending to that position, there is a moral obligation that all of us have enshrined in the Constitution of an advise and consent power to tell our truth. Because here, our power as individuals is made manifest by our ability to develop coalitions, but in the executive branch, and especially in the Attorney General's position, that power is residing in an individual. That power is real. That power has dramatic effects on the lives of everyday Americans. And so, when that is happening, we cannot remain silent. I am so proud that Senator Elizabeth Warren actually not just reading a letter of Coretta Scott King, she honored that Martin Luther King tradition. King said, "Our lives begin to end the day we begin to be silent about things that matter." King also wrote, "There comes a time when silence is betrayal." I can't betray my values or my ideals, and in this body that is, in many ways, a testimony to the ideals of freedom of speech in America, a body that is exhibiting, in many ways, to this country what fervent debate, why it's so important, the marketplace of ideas, to silence a voice, to silence a senator, that's unconscionable to me under the pretext of somehow it was impinging the character of another senator. That's unacceptable, especially in light of so many things that have been said on this Senate floor that weren't checked, weren't called out. But here, at a time that a senator is standing strong for what she believes and speaking her truth, there is what is tantamount to censure. I came to this body on a very auspicious day that I swore my oath. I joke, it was Halloween. I was sworn in on Halloween 2013. It's October, and my election was just days earlier. And 6 days before that, before I was elected to the United States Senate, my father died. I confess on that day I was feeling the sense of pride, standing right over there with the vice president. I was feeling pride, but I was hollow also in my heart. I was hurting because I knew my dad would have wanted to see me become a senator. This guy who was born poor in a segregated community in the South, in the mountains of North Carolina. He could have never imagined that one day his son would be sworn in as a United States Senator. And my dad taught me lessons that so many of our fathers did. I learned about hard work. I learned about sacrifice. James Baldwin said it best: children are never good at listening to their elders, but they never fail to imitate them. I thank God to this day that I had models to emulate. But if there's anything my father taught me, it is, son, you didn't get where you are on your own. Now that's interesting to me to hear from a guy that by every other measure was a self-made man. I mean, my dad, to watch him go at his craft, to watch him work and sacrifice. On snow days in New Jersey, I'm a little grade school kid, the first sound I would hear would be him shoveling the driveway because he was going to be the first person at work no matter what. And often I'd come home from school or go to my games. My dad wouldn't be there because he was going to make sure he was the last one to leave the office, setting the example as a manager. But yet here is this self-made man by the objective view who would look at me growing up every step of the way and let me know, son, sometimes it'd be boy, you didn't get here on your own. I'd walk around my house staring in the refrigerator. My dad would look at me and say, boy, don't you dare walk around this house like you hit a triple. You were born on third base. Well, yeah, I got it after years because my father said, son, you are where you are because of this nation. Not just of the values and ideals. I mean, come on. I want to tell the truth. This is a country that was formed with a level of genius that I can't take away from, a level of ascendant thought in the span of human history that is remarkable. And my father respected that. But he knew that what makes this country real was not just what our founders did, it was what average Americans did to make real on the promise of this democracy. That even when challenges in their country didn't face them themselves, they somehow fought to make this country more real, because as great as our founders are, as great as that Constitution is, let's look at those documents and be honest with each other. Native Americans are referred to as savages in our Declaration of Independence. Women aren't referred to at all. African Americans were fractions of human beings. What was the spirit that took an imperfect document and founding ideals and made them more perfect? What was that spirit? I want to read the words of Thurgood Marshall. He delivered them following remarks, the remarks in May of 1987. I was a high school student. It was on the occasion of the bicentennial of the Constitution itself. This is what he says. The year 1987 marks the 200th anniversary of the Constitution. A commission has been established to coordinate the celebrations. He goes on. Like many anniversary celebrations, the plan for 1987 takes particular events and holds them up as the source of all the very best that as follows. He writes, patriotic feelings will swell, promoting proud proclamations of wisdom and foresight and a sense of justice shared by the framers and reflected in the written documents now yellow with age. Now he writes, this is unfortunate. Not the patriotism itself, but the tendency for the celebration to oversimplify and overlook the many other events that have been instrumental to our achievements as a nation. The focus of this celebration invites a complacent belief that the vision of those who debated and compromised in Philadelphia yielded the more perfect union it is said we now enjoy. This is Thurgood Marshall. I cannot accept this invitation. For I do not believe that the meaning of the Constitution was forever fixed at the Philadelphia Convention, nor do I find the wisdom, foresight, and sense of justice exhibited by the framers particularly profound. To the contrary, the government they devised was defective from the start, requiring several amendments, a civil war, and momentous social transformations to attain the system of constitutional government and its respect for individual freedoms and human rights that we hold as fundamental today. When contemporary Americans cite the Constitution, they invoke a concept that is vastly different from what the framers barely began to construct 2 centuries ago. For a sense of the involving nature of the Constitution, we need look no further than the first 3 words of the document's preamble, "We the people." When the founding fathers used this phrase in 1787, they did not have in mind the majority of American citizens. We, the people, included in the words of the framers the whole numbers of free persons. On a matter of so basic as the right to vote, for example, Negro slaves were excluded, although they were counted for representational purposes as 3/5 each. Women did not gain the right to vote for over 130 years. These omissions, Thurgood Marshall writes, were intentional. The record of the framers' debates on the slave question is especially clear. The Southern states acceded to the demands of the New England states for giving Congress broad powers to regulate commerce in exchange for the right to continue the slave trade. The economic interests of regions coalesced. New Englanders engaged in the carrying trade, and it continues. Thurgood Marshall goes on to write that even the ringing phrases of the Declaration of Independence are filled with irony. For every draft of what became the Declaration assailed the King of England for suppressing legislative attempts to end the slave trade. The final draft adopted in 1776 did not contain the criticism. And so again, at the Constitutional Convention, eloquent objections to the institution of slavery went unheeded. Thurgood Marshall goes on to so eloquently discuss the evolutions it took to come to where we are today. He writes that the men who gathered in Philadelphia in 1787 could not have envisioned the changes that have taken place that resulted into the world in which he was living here in 1987. He writes they could not have imagined, nor would they have accepted that the document they were drafting would one day be construed by the Supreme Court, to which had been appointed a woman and a descendant of an African slave, Thurgood Marshall himself, that we, the people, no longer enslave. But the credit does not belong to the framers. The credit does not belong to the framers. It belongs to those who refused to acquiesce in outdated notions of liberty, justice, and equality, and who strived to make them better. So when I swore my oath days after my father died, after the man who passed, who taught me that the liberties and the freedoms and the privileges and the abundance that I enjoyed when I had the fortune of calling myself an American, that those liberties, those freedoms, the justice, the opportunity that I enjoy, yes, I may be a hard worker, yes, I may sacrifice, yes, I may struggle, that all of this, though, was made possible because of the fights and the struggles and the courage of others. It was made possible by people who did not sit on the sidelines of history, that understood that democracy is not a spectator sport, that even though it's not comfortable or convenient or easy, sometimes in the course of human events, for the cause of your country, you got to stand up and fight. And so before I swore that oath, my mom, before I hit this Senate floor and became a member of this august body, she took me across the Capitol to meet with another man because she wanted the last thing that I did to be a humble recognition upon whose shoulders I stood. The last thing I did before I became a U.S. Senator was to meet with John Lewis. Congressman Lewis, if you know him, you are shaken by his goodness and his decency. You're shaken by his kindness. I don't want to elevate him. He's not a perfect man, but this is a hero to me and to so many Americans. He is someone that lives his values, doesn't just preach them. And when I sat to have a meal with him, he had put a spread together. He told me that when I was sworn in as the fourth popularly elected African American in the history of this body, that it was a triumph for him, that it made him proud. And here I am standing before my mom's classmate at Fisk, my parents' generation, and he is elevating me and telling me how important this day is to him. And what's fascinating to me was he didn't just speak those words. I looked around his office and it was like a civil rights museum of people that marched for me and you and others, people that went on freedom rides for me and you and others, people that fought for voting rights for me and you and others. All the while I'm sitting there, he won't even let me get up. He is serving me food. That's his spirit. And what's incredible to me is it gives incredible testimony to this truth that this nation is great not because it was easy to get here, not because it was destined to be so, but because Americans all along in our history did the challenging thing to try to move this democracy forward. And so, does John Lewis love Senator Sessions? Yes. John Lewis is an embodiment of love. He's a man that has forgiven his attackers, who literally has had people that beat him years later become people that he embraces. And even though we love each other and respect each other, love is difficult and hard. It's not a being verb. It is a hard thing to do. Sometimes love requires telling the truth. Love requires not being silent. Love isn't politic, and sometimes love breaks traditions. I chose to testify against a sitting senator and took criticism for it, probably deservedly so. But I did so because when I testified, what made it more evidently clear or highlighted my decision is that I was sitting next to John Lewis. He never asked if it was convenient or politic for him to do freedom rides. He didn't ask if it was safe to march across the Edmund Pettus Bridge. He didn't ask if it might make people feel uncomfortable or make him the subject of scorn to go out and register to vote at a time when people were dying doing it, Goodman, Cheney, and Schwerner. No, he decided to do it because it was the right thing to do. I want to read from his testimony. On that day, I had the privilege to sit next to my hero. In a judiciary hearing, this is what he wrote. This is what he spoke. Millions of Americans are encouraged by our country's effort to create a more inclusive democracy the last 50 years. But what some of us call a beloved community, a community at peace with itself, we are not a minority. A clear majority of Americans said they want this to be a fair, just, and open nation. They are afraid that this country is headed in the wrong direction. They're concerned that some leaders reject decades of progress and want to return to the dark past when the power of law was used to deny the freedoms protected by the Constitution, the Bill of Rights, and the amendments. These are the voices I represent today. We can pretend that the law is blind. We can pretend that it is even-handed. But if we are honest with ourselves, we know that we are called upon daily by the people we represent to help them deal with unfairness in how the law is written and enforced. Those who are committed to equal justice in our society wonder whether Senator Sessions' call for law and order will mean today what it meant in Alabama when I was coming up back then. The rule of law was used to violate the human and civil rights of the poor, the dispossessed, people of color. I was born in rural Alabama, not very far from where Senator Sessions was raised. There was no way to escape or deny the chokehold of discrimination and racial hatred that surrounded us. I saw the signs that said white waiting, colored waiting. I saw the signs that said white men, white women, colored women. I tasted the bitter fruits of segregation and racial discrimination. Segregation was a law of the land to order our society in the Deep South. Any black person who did not cross the street when a white person was walking down the same sidewalk, who did not move to the back of the bus, who drank from a white water fountain, who looked at a white person directly in their eyes, could be arrested and taken to jail. The forces of law and order in Alabama were so strong that to take a stand against this injustice, we had to be willing to sacrifice our lives for our cause. Often, the only way we could demonstrate that a law on the books violated a higher law was by challenging that law, by putting our bodies on the line and showing the world the unholy price we had to pay for dignity and respect. It took massive, well-organized, nonviolent dissent for Voting Rights Act to become the law. It required criticism of this great nation and its great laws to move toward a greater sense of equality in America. We had to sit in. We had to stand in. We had to march. And that's why more than 50 years ago, a group of unarmed citizens, black and white, gathered on March 7th of 1965 in an orderly, peaceful, nonviolent fashion to walk from Selma to Montgomery, Alabama, to dramatize to the nation and to the world that we wanted to register to vote, wanted to become participants in a democratic process. We were beaten, tear-gassed, left bloody, some of us unconscious, some of us had concussions, some of us almost died on that bridge. But the Congress responded. President Lyndon Johnson responded. And the Congress passed a Voting Rights Act, and it was signed into law on August 6th, 1965. We have come a distance. We have made progress. But we are not there yet. There are forces that want to take us back to another place. We don't want to go back. We want to go forward. As the late A. Philip Randolph, who was the dean of the March on Washington in 1963, often said, maybe our forefathers and our foremothers all came to this great land in different ships, but we're all in the same boat now. It doesn't matter how Senator Sessions may smile, how friendly he may be, how he may speak to you, but we need someone who's going to stand up, speak up, and speak out for the people that need help, for people that have been discriminated against. And it doesn't matter whether they're black or white, Latino, Asian, Native American, whether they're gay or straight, Muslim, Christian, or Jews. We all live in the same house, the American house. We need someone as Attorney General who's going to look out for all of us and not just for some of us. And now he writes, he speaks, I ran out of time. Thank you for giving me a chance to testify. John Lewis had 5 minutes before the Judiciary Committee. 5 minutes to enter words into one of the greatest historical records of all time. The record of this body. The record of the Judiciary Committee. He brushed on issues that aren't passing fancy to him. He's lived for these issues. He has fought for these issues. He's dedicated his life to these issues. And this man, this champion, chose not to be silent. He had a window of opportunity. Doesn't mean he doesn't love Jeff Sessions. I know he does. Doesn't mean that he doesn't think that he's kind and collegial when the two meet. I watched them. When Senator Jeff Sessions and I were there to present him with a congressional medal. But what it means is that he has real concerns about the cause of our country because this nation has made such dramatic strides towards freedom and justice. It's made those strides because people like him folks from all different backgrounds didn't just pledge allegiance to the flag. They didn't just say the words liberty and justice for all. They put their lives on the line to make it happen. I've seen this kind of patriotism made real in my lifetime, from the men and women who put the uniform on to serve us overseas, all the way to men and women who put uniforms on to protect our neighborhoods, who make irrational choices every day to fight for our safety, our security, for our liberty, and for our justice. I stand here now to speak out against Jeff Sessions becoming the highest law enforcement officer of the land. Not because of any personal feelings I have about him, because I too, like I was called to do as a little boy in Sunday school, believe in the ideals of love thy neighbor. Doesn't detract from that love to speak up, speak my heart, speak my mind. Senator Elizabeth Warren stood up, speaking the words of Coretta Scott King. Doesn't detract from the collegiality of this institution for her to speak her mind. Especially when those are on issues that are at the core of our Constitution. Take voting rights. I don't have the authenticity to speak on voting rights that someone like John Lewis has, but I've watched what's happening in my country. All this talk coming from the highest office in the land about voting fraud. The chances of encountering in-person voter fraud in this nation is about the chances of you getting struck by lightning. You might even have a better chance of going and playing the lottery tonight and winning than encountering voter fraud. But what is a real issue is voter suppression. Now, I'm not just saying that as a partisan spouting. I'm actually referring to actual judicial inquiries of the federal government. In the state of North Carolina, as soon as the Shelby decision, before the ink got dry, states like North Carolina, Texas, and others started to change their voting laws. Well, it's hard to do things in the cover of night without the power to investigate what actually happened. A federal judge saw in North Carolina and said that they were discriminating against African Americans, that they had tailored this law, I think the quote exactly is, with surgical precision to discriminate against African American voters. This is not fiction. This isn't made up. This is the facts. There are still people in this country in positions of power who are seeking to pervert the law to discriminate against certain populations and advantage themselves politically. It's not just cheaters, but it's clearly discriminatory, in this case, on race. Now, if we know that's going on, John Lewis, myself, millions of Americans, Republicans, Democrats, Independents, believe that we should investigate these things. But the problem is we now have someone that's nominated to the very office, the Justice Department, that have said the activities around voting rights to investigate these issues is intrusive. At a time that we still have issues with voting, where states are moving not to open up the access to voting, not to make it easier, not to make it more free and fair, there are folks that are trying to create laws that are choking it. And some of these laws factually have been designed to disadvantage certain populations. The highest law enforcement officer in the land has an obligation to aggressively investigate these potential violations of law. But we've listened to what the priorities are of Senator Sessions. It's not to investigate what is real, what is substantive, what has happened and likely will happen. It's to investigate the fiction created, documented, that somehow millions of Americans woke up in the morning and said, hey, you know what I'm going to try to do? I'm going to try to go down to a polling place and fake my way into voting. Heck, it's hard to get millions of Americans to vote, period, sometimes. But somehow, this fiction is the highest priority when it comes to voting of this Attorney General. I will not be silent on this issue. I am here. We are here because people fought to stop violations of voting. And we as Americans should have confidence that a highest law enforcement officer in the land won't criticize any efforts on voter suppression, but will actually work to do something about it. Something else that was spoken about in John Lewis's testimony that is a real issue in America. And this has to do with the prevalence in this country of ongoing hate crimes. Now, Senator Sessions, as a senator, again, in a body in which one senator does not have the power to pass legislation, failed to stand with the majority of senators when it came to issues of laws that were designed to deal with bias-motivated crimes that target specifically people's sexual orientation and gender identity. There was a specific law, the Matthew Shepard and James Byrd Jr. law. These are people, two Americans, that were targeted because of their respective sexual orientation and race. Senator Sessions' comments at the time were that this law would, and I quote, cheapen the civil rights movement. Now, here you have in the testimony a civil rights hero talking about the challenges facing the LGBT community, civil rights hero that's joined with me and others decrying the fact that in this country right now, you may have the right to marriage equality, but still in most states in America, if you get married, you post it on your Facebook page, you go to work the next day, your boss says you're fired because you got married to someone of the same sex, there's no legal recourse. Senator Sessions on same-sex marriage even went as far as to say that it is not disputable that adopting a same-sex marriage culture undermines and weakens marriage. I don't even know what to say about a same-sex marriage culture. I would never question that love and that bond between two Americans that now is the law of the land. I don't know what it means to someone when they criticize a law that's going to work against violence. Now, please understand, this violence is not a rare thing like in-person voter fraud. We know that today, still too many lesbian, gay, bisexual, and transgender Americans feel unsafe in their communities. A significant percentage of gay and lesbian children report missing school because of fear. The data from the National Coalition of Anti-Violence shows that 20 to 24%, about 1 in 5 of lesbian and gay people experience hate crimes, and that LGBT Americans of color are particularly at risk. Often those hate crimes are utterly tragic. In 1998, Matthew Shepard was a 21-year-old student at the University of Wyoming. He went out to the bar that evening like many 21-year-olds do. 2 men offered him a ride home and he accepted, but instead of bringing him home, they brought him out into a field. They taunted him with epithets, hatred directed at him because he was gay. And then they beat him savagely and left him for dead. This is what one of our nation's magazines, Vanity Fair, this is what they wrote. The next day, a passing cyclist saw what he thought was a scarecrow lashed to a wooden buck fence on a remote plot of land. The scarecrow turned out to be Matthew, unconscious, a huge gash in his head, his face drenched with blood, except where his tear trails had washed it clean. His shoes were missing. And after police questioning, Aaron McKinney confessed that he and his friend Russell Henderson had met Matthew at the Fireside Bar and Lounge on that Tuesday night and posed as gay to lure him into their truck. Then they drove him to that out-of-the-way location, bound him to a fence, pistol whipped him, taunted him, while he begged them for his life. Then they abandoned this gentle, 5'2", 105-pound freshman to hang there for 18 hours, losing blood as his temperature dropped. In that same year, James Byrd Jr., a 49-year-old African-American man, was walking home from his parents' house in Texas when he was also offered a ride home. They didn't bring him home either. They brought him to the middle of the woods where he was beaten and then chained to a pickup truck and dragged along the road for 2 miles. He had been targeted by 3 white supremacists. The acting assistant attorney general for Civil Rights Division at the Department of Justice, Jocelyn Samuels, wrote the following in 2013. While the men responsible for the Shepard and Byrd killings were later convicted of murder, none of them were prosecuted for committing a hate crime. At the time these murders were committed, neither Wyoming nor Texas had hate crime laws, and existing federal hate crime protections did not include violent acts based on a victim's sexual orientation, and only covered racial violence against those engaged in a federally protected activity, such as voting or attending school. 4 years ago today, President Barack Obama signed the Matthew Shepard and James Byrd Jr. Hate Crime Prevention Act. It is the law of the land. This landmark legislation, championed by the late Senator Ted Kennedy, greatly expanded the federal government's ability to prosecute these hate crimes. The law enables the Justice Department to prosecute crimes motivated by race, color, religion, national origin, without having to show that the defendant was engaged in a specific federally protected activity. The Shepard-Byrd Act also empowers the department to prosecute crimes committed because of a person's sexual orientation, gender identity, gender or disability, also as hate crimes. The law also marked the first time that the words lesbian, gay, bisexual, and transgender appeared in the U.S. Code. Under the leadership of Attorney General Holder, the criminal section of the Civil Rights Division and the U.S. Attorney's offices around the country have used that law to address the most serious hate crimes. Over the last 4 years, 44 people in 16 states have been convicted under the Shepard-Byrd Act for their discrimination and crimes against others on the basis of race, religion, national origin, sexual orientation, gender identity, or disability. This is what we expect from the Department of Justice. Hate crimes against gays, lesbians, bisexuals, and transgender are tragically common in this country. Discrimination, hate, and violence is not rare in this community. It is real. It is a scourge. It must be stopped. And the highest law enforcement officer in the land must follow the federal law, must see it as a priority, must see it as an urgency, must use their prosecutorial discretion to put resources towards those prosecutions. And so when civil rights leaders like John Lewis understand the truth that the civil rights movement wasn't about black people, it was about American people, it was about justice for all, it was about freedom from violence for all, it was about equal rights for all, that he cannot be silent when someone is discriminated against because of how they pray or how they love. None of us can be silent if we believe in those words, liberty and justice for all. And at a time where this is a real problem, we should trust that the highest law enforcement officer would do something about it, that would vigorously and seriously defend and fight against the kind of horrific crimes that are still being perpetrated in America. But that's not all. We see that in his testimony, we see that Jeff Sessions spoke at length about this idea of law and order. Now, I respect that idea of law and order. But the call of our country isn't law and order. We've seen totalitarian states, we've seen dictatorships, we've seen all kinds of countries that restrain freedoms and liberties, find through repression and oppression. We found law and order can be established in many ways. This country was founded with a higher ideal to pursue. It's what has called so many Americans forth in pursuit of this higher ideal, that it's not just law and order, it's the pursuit of justice. And it's an understanding that, as King said, injustice anywhere is a threat to justice everywhere. And one of those fundamental principles of justice is this idea of equal protection under the law. The Attorney General has an obligation to pursue this idea of equal justice. Now, I used to be a mayor. And in the city in which I still live, in Newark, New Jersey, we were always looking to fight crime. And we knew lowering crime didn't just have to do with police. Sometimes police are busily working on the symptoms of the deeper problems, and we as a society have to address them. That's why drug treatment is such a critical way of delivering justice and fighting crime. That's why programs that help people coming home from prison help to lower crime. That's why mental health care is so important for fighting crime. But you cannot take it away from any American. The truth that there is so much of a need to celebrate our law enforcement in this country. I've watched law enforcement officers do acts of heroism and courage that show that they are worthy of the highest of celebration. And so many Americans don't know this. Don't understand that so many law enforcement officers every single day risk danger. And our law enforcement officers should be lauded for that. These great women and men that every single day are out in our communities, entering into difficult circumstances. I still remember with my police director one time being on the phone, there was an awful hostage situation, and we were discussing how to deal with it. Then in the phone, I heard gunshots go off, and suddenly in the background, I heard officers yelling, "Go, go, go, go." And these officers, hearing bullets firing, having no situational awareness whatsoever, stormed into that building. Now, most of us, when you hear gunfire, we would drop down. These men and women stood up. Most of us, hearing gunfire, might run in the other direction. These men ran toward that problem. I can give you countless examples of things, just as a mayor of a city working directly with police officers, I can give you great testimony to the strength and courage of our officers. And I commend Jeff Sessions for talking about how important our police officers are. But understand that it does not diminish our respect and our love and our admiration and our gratitude to police officers at all, to law enforcement at all in this country, to ask that we make sure through systems of accountability that we are holding law enforcement officers to the highest levels of professional conduct. There's not an officer I know that has any problem with that. And so this is what concerns me. We know in this country that we have challenges with the equal application of the law. One recent study from researchers at the University of Louisville and the University of South Carolina documented that unarmed black men were shot and killed in 2015 at disproportionately higher rates. We've seen other challenges with poor communities and African American communities having unjust usages of the law directed towards them. We all know about Ferguson, Missouri. The city's law enforcement practices disproportionately impacted African Americans. It was the Justice Department that investigated the Ferguson Police Department and found that from 2012 to 2014, blacks accounted for 85% of vehicle stops, 85%, 90% of citations, 93% of arrests. This is despite the fact that blacks only made up 67% of the total population. The information came to light because of the Justice Department's investigation. In Baltimore, the Department of Justice found that the Baltimore Police Department targeted policing of certain Baltimore neighborhoods with minimal oversight or accountability, disproportionately harming black residents. That the Baltimore Police Department stops African American drivers at disproportionate rates. African Americans accounted for 82% of all vehicle stops compared to 60% of the driving age population in the city, and only 27% of the driving age population in the greater metropolitan area. Racial disparities in Baltimore Police Department's arrests are more pronounced for highly discretionary offenses. Blacks accounted for 91% of the people charged solely with failure to obey or trespassing. 89%, blacks were 89% of the 1,350 people charged for making a false statement to an officer, and 84% of the people who were arrested for disorderly conduct. Now, these challenges with policing are complex. Even communities very conscious and sensitive to these issues struggle with the equal application of justice. I don't just say this, I experienced it. When I was a mayor of Newark, we were making a very conscious effort to improve, and yet we still found difficulties. When the Department of Justice came to our city, they were able to do data gathering that we did not do, perhaps didn't have the resources, didn't understand the urgency. But when the Department of Justice came in and pulled that data, put a lot of resources into analyzing, they found that about 80% of the Newark Police Department stops and arrests involved blacks, while the population is 53.9% black. Black residents of Newark were at least 2.5 times more likely to be subjected to a pedestrian stop. The data that was pulled by the Department of Justice helped us to step up our work with the ACLU and others and begin to address these issues. The Department of Justice's investigations, accountability, working with local law enforcement departments has helped to make change in Newark, in Ferguson, will help make change in Baltimore, and all around our country. But Senator Sessions has aggressively criticized the use of these kind of consent decrees, this kind of intervention. This is a critical tool that the Justice Department is now using to curtail patterns and practices of discrimination within police departments. But Senator Sessions calls them an end run around the democratic process. During his confirmation hearings, Senator Sessions says, "I think there is a concern that good police officers and good departments can be sued by the Department of Justice when you just have some individuals within a department doing things wrong." Now, that's problematic to me because it is a failure to understand the larger challenges we have with policing in America. That this is not something that is just a few bad officers. And even that construction of this idea that it is somehow bad officers versus good officers, when it comes to implicit racial bias and how it is impacting law enforcement in America. Sometimes people don't even feel comfortable with those terms, implicit racial bias, as if it's somehow calling people racist, which it's not. It's actually this idea that we at the federal government, the Justice Department, working with localities, can actually help departments begin to address the reality in this country that we have a justice system that does not have equal application of law enforcement. A real problem in this country. And when I say it's a real problem, again, this is not a partisan issue. FBI Director James Comey, one of our highest law enforcement officers, to my knowledge, he's a Republican. This law enforcement officer speaks with clarity about the urgency and the need to address this issue within American policing. He says, unfortunately, in places like Ferguson and New York City, and in some communities around this nation, there is a disconnect between police agencies and many citizens, predominantly in communities of color. Serious debates are taking place about how law enforcement personnel relate to the communities they serve. This is Director Comey writing, or in a speech he gave. Serious debates are taking place about how law enforcement personnel relate to the communities they serve, about the appropriate uses of force, and about real and perceived biases, both within and outside of law enforcement. These are important debates, Director Comey says. Every American should feel free to express an informed opinion, to protest peacefully, to convey frustration and even anger in a constructive way. That's what makes our democracy great. Those conversations, as bumpy and as uncomfortable as they can be, help us understand different perspectives and better serve our communities. Of course, these are only conversations in the true sense of that word if we are willing to talk, but to listen too. Director Comey continues in his speech, I worry that this incredibly important and incredibly difficult conversation about race and policing has become focused entirely on the nature and character of law enforcement officers, when it should also be about something much harder to discuss. Debating the nature of policing is very important, but I worry that it has become an excuse at times to avoid doing something harder. Much research points to the widespread existence of unconscious bias. Many people in our white majority culture have unconscious racial biases and react differently to a white face than a black face. We simply must find ways to see each other more clearly. And part of that has to involve collecting and sharing better information about encounters between police and citizens, especially violent encounters. The first step to understanding what is really going on in our communities and in our country is to gather more data related to those we arrest, those we confront for breaking the law and jeopardizing public safety, and those who confront us. Data seems a dry and boring word, but without it, we cannot understand our world and make it better. How can we address concerns about use of force? How can we address concerns about officer-involved shootings if we do not have a reliable grasp on the demographics and circumstances of these incidents? We simply must improve the way we collect and analyze data to see the true nature of what's happening in all of our communities. The FBI tracks and publishes the number of justifiable homicides reported by police departments. But again, reporting by police departments is voluntary, and not all departments participate. That means we cannot fully track the number of incidents in which force is used by police or against police, including non-fatal encounters, which are not reported at all. Without complete and accurate data, we are left with ideological thunderbolts. And that helps to spark unrest and distrust and does not help us to get better. Because we must get better. I intend for the FBI to be a leader in urging departments around this country to give us the facts we need for an informed discussion, the facts of us that we need to help us to make sound policy and sound decisions with that information. Now, this is the FBI director that's talking about the urgency of collecting data. And what the Justice Department has been doing for departments where people are making a case for bias in policing, I know this because it happened in Newark. The Justice Department comes in and collects data and analyzes the data and comes to objective conclusions that are not, as Director Comey says, ideological thunderbolts. And what they seem to be finding where they go in and do these investigations is, you know what? A lot of these communities have a right to be upset. because the policing practices do reflect bias. And there is not an equal application of the law. And if we are to breed understanding and cooperation, trust me, I know this, to lead to even more effective policing, better police-community relations, we need to get the data out there. But we now have someone who is nominated to the highest law enforcement office in the land that has criticized this kind of work. That at a time that over the last few years, we've seen cities erupting in protest. We've seen the call of hundreds and hundreds of thousands, if not millions of people, trying to talk about Black Lives Mattering. At a time that people are questioning law enforcement, what Director Comey and others are saying, hey, let's get to the bottom of this. Let's not talk from sentiment or feeling. Let's talk from experience and data. And so Senator Sessions' views on this are out of date. They run contrary to where criminal justice reform is moving. And they're in direct conflict with the people that his office obliges himself to serve. Given what he has said on the record, we can have no confidence that the issue of policing will be a priority if he is leading the Justice Department. In fact, we actually, with some certainty, can be confident that the Justice Department will not do this kind of aggressive data collection to understand the facts, the kind of work that the FBI director is calling for. But it's not just the FBI director. Listen to a letter from a group of over 160 law enforcement officials that was sent to the Senate about the need for comprehensive criminal justice reform. And they write, I quote, as current and former leaders of the law enforcement community, police chiefs, U.S. attorneys, federal law enforcement, and heads of national law enforcement organizations, we believe that protecting public safety is a vital goal. Our experience has shown us that the country can reduce crime while also reducing unnecessary arrests, prosecutions, and incarceration. We believe that the Sentencing Reform and Corrections Act will accomplish this goal, and we respectfully urge you to support it. We appreciate your leadership on and concern for the important criminal justice issues facing the country today. Our group of law enforcement leaders to reduce crime and incarceration unites more than 160 current and former police chiefs, district attorneys, U.S. attorneys, and attorney generals from all 50 states. Our mission is to replace ineffective police policies with new solutions to both reduce crime and incarceration. To achieve this goal, we focus on 4 policy priorities. One of which is reforming mandatory minimum sentences. Let me pause there for a second. The wisdom in law enforcement now understands that you've got to build faith and legitimacy in a department, and you do that through police-community relations. Law enforcement officers know that data collection is important. When I was mayor of Newark, we made CompStat stronger and better in analysis of crime patterns and data. We use it to more effectively fight crime. But in a time of heightened suspicion and concern, in a time where leaders are talking about the reality of implicit racial bias, the highest law enforcement officer in the land should respect the truth and direction of criminal justice reform, but it's not just in policing. It's also in how we're looking at overall criminal justice reform. In the United States of America, we have seen now that our criminal justice system, since about 1980 on the federal level, has grown close to 800%, costing us as taxpayers billions and billions of dollars to lock up nonviolent offenders. We're disproportionate with the rest of the country, with the rest of the planet Earth. We've only got 4 to 5% of the planet Earth's population, but 1 out of every 4 imprisoned people on the planet Earth are right here in the United States of America. Now, do not tell me that when it comes to human beings on the planet Earth, Americans have a greater proclivity for criminality. That is just not true. But yet, our so-called war on drugs took us from being on par with the rest of the planet Earth and suddenly shot us up with an 800% increase on the federal level, 500% overall in our nation, in throwing people in jail, disproportionately, overwhelmingly nonviolent people. And this drug war, incontrovertibly, has been persecuted on the poor. Drug laws are not equally enforced in this country. Leading one great legal mind in our country, Brian Stevenson, to say, we have a nation that seems to sometimes treat you better if you're rich and guilty than poor and innocent. Well, let me tell you, in America, if you just use the lens of race, there's no difference between blacks and whites for using drugs or dealing drugs, none whatsoever. But if you're African American, you're about 3.7 times more likely to be arrested for those nonviolent drug crimes. But the truth is, if you use just race, socioeconomic status, you look at these issues, you see the poorest Americans disproportionately filling our jails and prisons. But what's worse than that, disproportionately you see addicted Americans not getting treatment, getting jail time. Mentally ill people not getting health care, getting jail time. All of this running up the bill to a point in American history around the time I went to law school to the time I became mayor of Newark, we were building a new prison about 1 at every new 12 days. The rest of the world was building better bridges, faster trains, better infrastructure than us. Our infrastructure has been crumbling, but hey, as we're battling out for infrastructure bills in this body, or hopefully will be, the reality is we've been building out infrastructure like crazy, putting the rest of the earth to shame when it comes to building one type of infrastructure, prisons. Overwhelmingly, disproportionately warehousing poor people, addicted people, mentally ill people, and people of color. Now, what's beautiful about this issue, amidst all the negativity that I'm expressing, is that there is a bipartisan coalition of Americans that range from Grover Norquist to Newt Gingrich, Koch brothers, Heritage Foundation, the American Enterprise Institute. These are all folks on the right who believe we need to reform our criminal justice laws. Joining with people like me who are Democrats and independents, Christian evangelicals who know what the Bible says about people in prison, all these coalitions, from libertarians to Christian evangelicals, even some vegetarians, we all are coming to a national consensus on criminal justice reform. In this body, you've got Patrick Leahy, Dick Durbin partnering with the chairman of the Judiciary Committee, Chuck Grassley, Mike Lee, Senator from Texas, Cornyn, who all came together to put together a bill that was talked about by these law enforcement officers. A bill that would help us to bring justice to our criminal justice system. A bill that would help us reduce the level of incarceration, but empower people to be more successful. And what's astonishing about this is this wasn't a bill showing leadership. It was showing followership. Because similar bills are being passed in states all across our country, from Georgia to Texas. And guess what they're finding out? When they lower their prison populations, they lower crime as well. And these mandatory minimums in our country have perverted our criminal justice system. In fact, most people still think we have a criminal justice system that's about courts and judges and juries, but that's not the case. Since we've seen this war on drugs, this race to put more and more mandatory minimums, what's actually happened is now most criminal convictions happen through plea bargain. About 98% are done through plea bargain, not trials anymore. There's a great book written about why innocent people plead guilty. That's because you suddenly have a nonviolent drug offense for doing things that past presidents have admitted to doing, but you've got a mandatory minimum charge thrown at you that you either plead to guilty or we're going to take you in for the 5 years or more. Well, our law tried to do the obvious, lower these mandatory minimums. Stop wasting taxpayer money by putting nonviolent criminals in jail for extraordinarily long times. I just was at a federal prison in New Jersey, and I had the warden walking with me telling me, there are people in here way too long. They're not a danger, but we're paying tens of thousands of dollars a year to lock them up. Meanwhile, our kids can't get money for public schools. We can't get money for fixing our roads. And so this bipartisan coalition came together, put together legislation that reflects what's happening in the states, that would have brought more justice to our criminal justice system. But it was fought against and criticized by Jeff Sessions. But even beyond that, the Justice Department, acting on its own, has been lowering mandatory minimums, has been giving instructions to prosecutors on nonviolent drug offenses not to use the mandatory minimums. And so, with all of this, from policing to sentencing to rehabilitation, to access to drug treatment, all of this reform that's going on, not in a partisan way at all, one of the few people standing against this bipartisan work, not just criticizing the legislation, but criticizing the Justice Department for their work, has been Jeff Sessions. Now, why is this an issue that, just like voting rights, LGBT, freedom from fear and freedom from violence, women's rights, why is this issue important? Why is it an issue that should be seen as so fundamental to our country? Well, we're seeing the issue of mass incarceration affect our nation in ways that most people don't fully understand. From voting rights, 1 out of every 5 black people in the state of Florida, 1 in 5 black folks in Florida have lost their right to vote because of felony disenfranchisement, overwhelmingly involving drug crimes. Often doing things, again, that people in Washington and elected offices have admitted to doing. It affects voting rights. It affects poverty. One study came out that we'd have about 20% less poverty in America if we had incarceration rates that were similar to other nations. Why? Would we have 20% less poverty if we didn't have 25% of the globe's prison population? Well, because when you make that mistake for doing something that George Bush or Barack Obama admitted to doing, when you create that felony crime, what happens is you come out of prison and you can't get a Pell Grant. You come out of prison and you can't get a job. Come out of prison and you can't get food stamps. You have door after door closed to you. And so these issues taken together are more than just about incarceration. It's about public safety. It's about empowering communities. It's about equal justice under the law. The most powerful law enforcement office in the land sets priorities and has to drive forward the ideals of our country. We are a nation that is great, not just because, as I said earlier in my remarks, of our founding documents, which, as Thurgood Marshall wrote, took a civil war and amendments, took an expansive vision of who is included in that ideal of we the people. But it's the spirit of America that has pushed forward, where people in positions of power, as well as grassroots folks, embody that great American spirit. I want to read what one of our great Americans, a man named Learned Hand, Judge Learned Hand, wrote in a speech called The Spirit of Liberty. He hand-delivered this speech during World War II to 1.5 million people. It was a time that a whole bunch of newly naturalized citizens were there. He spoke to first-generation Americans and folks that perhaps could have traced their lineage far, far back. He writes, "We have gathered here to affirm a faith in a common purpose, a common conviction, a common devotion. Some of us have chosen America as a land of our adoption. The rest have come from those who did the same. For this reason, we have some right to consider ourselves a picked group, a group of those who had the courage to break from the past and brave the dangers and the loneliness of a strange land. What was the object that nerved us, or those who went before us, to this choice? We sought liberty, freedom from oppression, freedom from want, freedom to be ourselves. This then we sought, this we now believe, that we are by way of winning." But what do we mean when we say that, first of all, we seek liberty? I often wonder whether we do not rest our hopes too much upon Constitution, upon laws, upon the courts. These are false hopes. Believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it. And what is this liberty which must lie in the hearts of men and women? It is not the ruthless, the unbridled will. It is not freedom to do as one likes. That is the denial of liberty and leads straight to its overthrow. A society in which men recognize no check upon their freedom soon becomes a society where freedom is the possession of only a savage few, as we have learned to our sorrow. What then is the spirit of liberty? I cannot define it. I can only tell you my own faith. The spirit of liberty is a spirit which is not too sure that it's right. Spirit of liberty is that spirit which seeks to understand the minds of other men and women. The spirit of liberty is the spirit which weighs their interests alongside its own without bias. The spirit of liberty remembers that not even a sparrow falls to the earth unheeded. The spirit of liberty is the spirit of him who, near 2,000 years ago, taught mankind that lessons it has never learned, but has never forgotten. That there may be a kingdom where the least shall be heard and considered side by side with the greatest. And now, in that spirit of an American which has never been and which may never be, nay, which never will be except as the conscience and courage of Americans to create it. Yet in the spirit of America which lies hidden in some form in the aspirations of us all, in the light of that America for which our young men are at this moment fighting and dying, in that spirit of liberty and of America so prosperous and so safe and contented, we shall have failed to grasp its meaning and shall have been truant to its promise, except as we strive to make it a signal, a beacon, a standard to which the best hopes of mankind will ever turn. In confidence that you share that belief, I now ask you to raise your hands and repeat the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. It's this spirit that, to me, must be emboldened in our country. We still have work to do. We still have challenges. We still have unfinished business. We have a position of Attorney General because there is still injustice. It's not just the fact that we still have crime in communities, still have people that live in fear of violence. That's a reality. But there's also people that live in fear of hatred and in fear of discrimination. There's people who often don't have people at the local level to go to, and only the federal government can play that role of strident actor for justice. There are still people that, after all these years, who have their basic American freedoms, like their right to vote, being undermined. Where people in power are trying to craft ways to discourage, to stop them from exercising that franchise. We still have a nation in which people are striving for justice. I'm proud of the voices we've heard tonight. I'm proud of my colleague Elizabeth Warren, who felt the need to stand up and speak her truth. I'm proud of heroes like John Lewis, who testified and told his truth. I realize that the hour's late, that the senator from Hawaii is now here. I oppose the nomination of Jeff Sessions. We'll vote no on the floor, and I hope my colleagues will join me in doing so as well. Mr. President, I yield the floor.
Mr. President.
The senator from Hawaii.
Thank you, Mr. President. Mr. President, I'm an institutionalist. I believe in this place. I love this place. People don't always like the rules or how they're interpreted, how they're administered, but the rules have historically differentiated the Senate from any other legislative body in the world, and I believe in that. But what Senator Warren did earlier tonight was not over the line. And here we are worrying about decorum and Rule 19, which says that no senator in debate shall impute to another senator any conduct or motive unworthy or unbecoming a senator. And let's be really clear here. This would not be a problem if Senator Sessions were not a senator. In other words, anytime a senator is nominated for a cabinet position, you can be as positive as you want. But if you want to be tough on a senator who has been nominated, as we have been on Rex Tillerson or Betsy DeVos, you run a risk of breaking the rules. Now, let's pause a moment to understand how divorced from reality this is. While debating Jeff Sessions as the next Attorney General, Elizabeth Warren crossed an invisible line, and a rule almost never used was invoked. The rule was not invoked when somebody called another member a cancer. The rule was not invoked when somebody called another member a liar. Now, this is ridiculous, but it's actually not the main point. Here's the point. Lots of people, almost everybody in the world, everybody in this country, do not have the luxury of worrying about decorum. What a luxury we have to debate if a stray comment crossed some theoretical line. This place of privilege, this place, the dome next door built by slaves, this place where there were hardly any women or people of color or gay people out of the closet until very recently, and yet we spent hours worrying about whether Elizabeth hurt Jeff's feelings or broke a sense of decorum. What a luxury it is to worry about that. In the meantime, Muslim families in America are terrified. In the meantime, DACA kids are worrying about whether they have to go into hiding. In the meantime, LGBT youth are bullied in school. In the meantime, anti-Semitic attacks are on the rise across the country. And we're here worrying about if it's impolite to quote in full the statement of Dr. Martin Luther King Jr.'s widow. Look, I am for this body. I am old school. I like the rules. I spend a lot of time talking to the parliamentarian and this desk so I can better understand it. But this body and its rules have to be in service to the country. The country is not in service to the rules and the body of the Senate. Before I go on, I just want to thank the stenographers who are such a critical aspect of the Senate and have been running marathon sessions, literally marathon sessions. We rotate through. There are at least 30 of us doing about 30 hours of debate, but there are only 7 of you. And your wrists are sore, your legs are sore. This is incredibly challenging, and yet without you, we have no Senate record. And so thank you for your service and your contribution to the world's greatest deliberative body. In his final speech as Attorney General, Eric Holder gave us a warning, and one that remains relevant in the Senate today. And he said, "Beware of those who would take us back to a past that never really existed, or that was imbued with a forgotten inequity. Our destiny as Americans is always ahead of us. Today, our country faces a stark choice. Do we want to pursue an imaginary past, or do we want to continue to follow the path towards progress? Do we continue in our struggle to form a more perfect union to secure the blessings of liberty? It's hard to believe, but these are the dramatic choices before us as we consider the cabinet nominations of this administration. And that choice is perhaps most clear in the nomination of our colleague, Senator Jeff Sessions, for Attorney General. The Attorney General is the highest law enforcement official in the country. He or she is the defender of American values, of human rights, and of civil rights. And this person needs to have an unbreakable commitment to fight for what's right and to lead that pursuit in making America more free and more just. That's the kind of approach we need because that's what the job demands. The Attorney General leads the #1 watchdog for civil rights in our country. This person leads a department charged with protecting voting rights and prosecuting human trafficking and hate crimes. They determine and defend the constitutionality of U.S. policies. Our next AG will face critical challenges that will test our justice system and our values. We need a leader committed to protecting the rights of every American, regardless of race, religion, gender, national origin, or sexual orientation. While I do like him as a colleague, Senator Sessions is the wrong person to serve as our nation's Attorney General. In my judgment, his policies, priorities, and his overall philosophy fall short of the standard our country has for the leader of the Justice Department. Throughout Senator Sessions' career, he has been on the wrong side of history. And if you look at the key issues this Attorney General will work on, it's clear that Senator Sessions' views fall outside of the mainstream of America. And that is certainly true when it comes to criminal justice. Look at Senator Sessions' opposition to the Sentencing Reform and Corrections Act. This bill was a big deal. It would have reduced mandatory minimum sentencing for low-level, nonviolent crimes while keeping tougher penalties for serious or violent crimes. It would have strengthened drug addiction rehabilitation and mental health treatment and improved our efforts to help people who are leaving prison to settle into their communities and get back on track. And everybody liked it. Senator Grassley introduced it with co-sponsors from both sides of the aisle. The bill had support from the House Speaker, the International Association of Chiefs of Police, the Major County Sheriff's Association, the National District Attorneys Association, the Leadership Conference on Civil and Human Rights, among many others. Even the Koch brothers liked this piece of legislation. And that's because it tackled problems that we can all agree needed to be solved. No one wants to see excessively punitive sentences that expand the federal prison population, which has grown by 734% between the year 1980 and 2015. And no one wants to see unnecessary barriers that make it harder for the formerly incarcerated people to stay out of jail. And no one wants to see taxpayer money spent needlessly. And so we had a thoughtful, bipartisan bill, but we were not able to enact it into law. Senator Sessions personally blocked the bill from being considered after it passed the Judiciary Committee last Congress. And he said, quote, federal drug and sentencing laws have already been considerably relaxed. The failure of reform impacts the lives of people who are hurt by unfair and outdated sentencing rules. It affects the families and communities of color, especially, who have been ravaged by the over-incarceration of minorities. The ACLU reports the sentences imposed on black men in the federal system are almost 20% longer than sentences imposed on white men with similar crimes. Think about that. The same crime, and you get 20% more time if you're African American. And while people of color are just as likely as white people to sell or use illegal drugs, they are more likely to be arrested. Think about how preposterous that is. Equal justice for all, right? Equal application of the laws. And yet, people of color and Caucasians use drugs and distribute drugs in the same percentages, and yet they're more likely to be arrested. African Americans make up 14% of regular drug users, but 37% of people arrested for drug offenses. And this raises the question of bias in law enforcement. But Senator Sessions opposes holding state and local law enforcement accountable for racial bias in policing or the excessive use of force. He's called the approach the Justice Department took to this accountability an end run on the democratic process. He has attacked bipartisan efforts to reduce the sentences of nonviolent, low-level drug offenders. And he opposed President Obama's initiative to address racial disparities in our criminal justice system and restore fairness by granting clemencies. Senator Sessions was critical of a Justice Department initiative that reduced overcrowding in federal prisons by 20% over just 3 years. And Senator Sessions' views on drug policy are maybe even more out of the mainstream. He has been one of the most outspoken advocates against the legalization of marijuana, both recreational and medicinal. In an April 2016 hearing, he suggested that the federal government must send the message that, quote, good people don't smoke marijuana. This is 2016. This isn't 1975. This is 2016. Our Attorney General nominee says, good people don't smoke marijuana. Tell that to the cancer victim. Tell that to my good friend John Radcliffe, who has stage 4 liver and colon cancer. But Senator Sessions supports aggressive federal intervention in states that have legalized medical or recreational marijuana. He criticized the federal government's guidance on federal marijuana regulation, which directed the Justice Department to respect the decisions of states to determine their own criminal laws. Because of this guidance, federal prosecutors stopped targeting patients who rely on medical marijuana products for relief. They stopped targeting local dispensaries that are operating squarely within state law. And instead, they went after criminal drug traffickers and violent drug crimes. That seems like a smart prioritization of resources within the Justice Department, not going after people who want to utilize marijuana to alleviate pain, but rather going after violent drug crimes. That seems smart, but Senator Sessions opposed that. The respect for federalism reflected in the Justice Department's guidance should be right in line with conservative values. Under the guidance, as long as states are preventing the distribution of marijuana to minors, if they're preventing the growing of marijuana on federal lands, and if they're stopping state-authorized marijuana activities being used as fronts for other illegal activities, then the Justice Department doesn't interfere. I'd like to quote from Senator Sessions' arguments against this policy. He said, I think one of Obama's great failures, it's obvious to me, is his lax treatment in comments on marijuana. It reverses 20 years almost of hostility to drugs that began really when Nancy Reagan started Just Say No. But here's the thing. There is a bipartisan consensus now. The drug war is a failure. The drug war did not work. The drug war did not decrease the percentage of people utilizing illegal drugs. Every time the government succeeded in shutting down a drug trafficking ring, another would pop up. And harsh penalties didn't slow addiction rates. They just incarcerated mostly young men. They didn't slow the flow of drugs. Instead, they crowded our prisons, burdened taxpayers, and increased drug-related violence in other countries. So now is the time to shift our strategy and focus on helping people who struggle with addiction. We also need to respect the decision in many cities and states to decriminalize drug possession. It's up to them to decide how to provide relief to residents who could benefit from using medical marijuana. There's another area where I believe Senator Sessions is out of the mainstream, and that is his views on LGBTQ equality. Senator Sessions opposed the Employment Non-Discrimination Act, a bill that I was proud to support that would have ended workplace discrimination for LGBTQ people. Right now, there are no federal laws that explicitly protect LGBTQ individuals from discrimination. That's not because we haven't tried. Last Congress, I co-sponsored a bill to prohibit this kind of discrimination. But even without a law on the books, the Justice Department has interpreted the Civil Rights Act to include sexual orientation and gender identity. That could change, however, under the next Attorney General. Senator Sessions, as head of the Justice Department, could choose to interpret the law differently. And his record gives us every reason to be concerned. Senator Sessions also voted against the reauthorization of the Violence Against Women Act. He voted against the reauthorization of the Violence Against Women Act because of a provision that ensures that victims of domestic violence are not turned away because of their sexual orientation or gender identity. This is why he voted against VAWA, because there was a provision that says you have to provide the services to individuals regardless of their sexual identity. He advocated for stripping that provision and ultimately voted against the bill. And as Attorney General, he could choose not to enforce this non-discrimination clause. Think about this. So if a gay person is a victim of sexual assault, are they not morally and legally entitled to the same humanity, the same protection under the law? And Senator Sessions has repeatedly opposed hate crimes protections for LGBTQ Americans, even attempting to insert a poison pill amendment to try to stop the 2009 Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act from moving forward. He has argued against federal prosecution of hate crimes, saying on the Senate floor that there is no need for the Justice Department to get involved. As Attorney General, Mr. Sessions would be in charge of enforcing the Hate Crimes Prevention Act. It is not a stretch to ask whether or not his enforcement would be vigorous. In fact, Senator Sessions has repeatedly supported laws that criminalize the LGBTQ community. In the 1990s, he tried to block an LGBTQ student conference. This is a student conference for young gay kids, arguing that it, quote, promoted a lifestyle prohibited by sodomy and sexual misconduct laws. He argued against a conference for kids to give each other support, to come up with strategies to survive bullying, to understand that what they're going through, other kids are going through, arguing that it promoted a lifestyle prohibited by sodomy and sexual misconduct laws. And he sharply criticized the legal decision that put a rightful end to the criminalization of same-sex relationships. He supported Don't Ask, Don't Tell, saying that it was pretty effective. And he opposed the repeal of that law. On marriage equality, Senator Sessions has vowed to work, quote, again and again to amend the Constitution to prohibit same-sex marriage. And we went through this in 1998 in the state of Hawaii. How unusual it is to enshrine in the Constitution the removal of a right. Right? I mean, I want you to just think about that. That you want to amend the Constitution not to provide additional rights, not to clarify something, but to explicitly prohibit Americans from having a certain right. I don't think there are many families who would agree with Senator Sessions' views here. People don't want their sons and daughters to have to hide their sexuality in order to serve their country. They don't want to go back to the days when our nation failed to recognize the legitimacy of same-sex relationships. And they certainly don't want to see their friends and family lose a job or even go to jail because of who they love. But that is the record that we are dealing with. And to be clear, these aren't views from the 1970s. These are his views as of last year. These are his current views on these matters. The senator has a similarly out-of-step approach on immigration. Mr. Sessions was instrumental in defeating the 2007 immigration reform bill, referring to it as terrorist assistance. He was a strong opponent of the 2013 bipartisan immigration bill, even though the bill had the strongest border security provision ever seen in an immigration bill and was voted. It was actually such a strong border security provision that I hated it. I had to think about whether I was going to vote for this thing because I felt that it was too much of a militarization of our southern border. I thought it was a giveaway and a waste of money. But it had a strong border security provision. It was voted out of the Senate by a wide margin. But if it were up to him, we would also limit legal immigrants coming to our country. During the markup in the Judiciary Committee, Senator Sessions offered an amendment to limit legal immigration, which failed 17-1. If you're wondering whether this is a rhetorical flourish to say that his views on immigration are out of the mainstream, the record shows 17-1. 17-1 in the Judiciary Committee. In addition, Senator Sessions supports cutting federal funding for sanctuary cities. And sanctuary cities has become sort of a brand. People aren't really even sure what it means. But here, let's be clear about what we mean by that. Stripping funding from sanctuary cities is wrong because cities have decided that the strength of their relationship between their police and their citizens is more important for public safety than doing the federal government's job of enforcing immigration laws. And Senator Sessions, of course, is against the right of children born in the United States to be American citizens. He is against helping the many dreamers in this country. Let's have an honest discussion about immigration. And we need to start talking about why people come to this country. Some of them come because they want to escape their own awful circumstances and live in freedom and opportunity. It's my grandparents escaping Ukraine. It's my wife's grandparents leaving China. It's the Schatzes. It's the Binders. It's the Kwaks. It's Albert Einstein. It's Madeleine Albright. This is who we are. We are people from all over the world who are united not by our ethnic extraction or our religious affiliation, but tied together by our love for America and our belief in this country as the beacon of hope, the shining city on the hill. And the idea that we would shred that legacy in the face of some imaginary public desire for immigration reductions, frankly, it's disturbing. Look at the protests happening every weekend at our country's international airports. Americans are not out in the streets demanding that we shut off the lamp outside the Golden Door. They are demanding that we stay true to our history and to our roots. That's why we saw close to 100 companies file a legal brief earlier this week against the Muslim ban put in place by the president and implemented by a man who has been mentored by Senator Sessions. The brief they filed notes an important statistic about our country. More than 200 companies currently listed on the Fortune 500 list are founded by immigrants or the children of immigrants. And this stands in direct contrast to the nominee's views here. Because if immigrants are coming to the United States and starting businesses and hiring people, they aren't taking jobs from Americans, they're creating jobs for Americans. And that has been the story of our country since the very beginning. Immigration is one of the cornerstones of our country, and the nominee's policy proposals would chip away at that. The world is watching, history is watching. We have to ask ourselves, what do they see? Do they see Lady Liberty, or do they see something else, something darker? Our country is asking similarly ominous questions about the basic, most fundamental right in our society, and that is the right to vote. Our country's history books are filled with stories of struggle for voting rights, of African American men risking it all to go to the polls, to women in white marching through the streets of Washington, D.C., demanding to vote. But that struggle and that progress is in danger with the kinds of policies that are being promoted. And it's on all of us to honor that history and make sure that everyone who is eligible to vote is able to vote. This is the bedrock of all other rights, because it is what gives us a voice when incumbent leaders and our representatives fail to protect the other rights. In his testimony to the Senate Judiciary Committee, Mr. Sessions said, the Department of Justice must never falter in its obligation to protect the civil rights of every American, particularly those who are most vulnerable. A special priority for me in this regard will be aggressive enforcement of our laws to ensure access to the ballot for every eligible American voter without hindrance or discrimination, and to ensure the integrity of the electoral process. But his record does not support that view. Senator Sessions supports voter ID laws that will disenfranchise many, many voters. He has called the Voting Rights Act intrusive, and he has praised a Supreme Court ruling that dismantled a key part of the Voting Rights Act. He has already had his nomination rejected by the Senate because of his views on this issue. And this should concern anyone and everyone who cares about our democracy. Because at the most basic level, democracy is built on the ability of American citizens to go to the polls. Let's be honest, our right to vote is being restricted. It is being restricted even though the United States has some of the lowest voter turnout of any developed democracy on the planet. And it's being restricted based on a lie. There is no voter fraud. Voter fraud is not the problem. Voter disenfranchisement is the problem. I talked with a buddy of mine back home who was watching Fox News and he was watching MSNBC, and he said, Democrats are saying there's voter disenfranchisement and Republicans are saying there's voter fraud, and I don't know what to believe. Well, here's facts. Here are the facts. There is a vanishingly small amount of voter fraud. You are more likely to be struck by lightning than to be convicted of voter fraud. This is a made-up problem. Now, why would you make up a problem such as this? Because it gives you a context and a pretext to do the systematic dismantling of voting rights. And this is happening in North Carolina. This is happening in Wisconsin. This is happening all over the country. The final policy area I'd like to raise is women's rights. The nominee's record is very clear on these issues. He opposed the Lilly Ledbetter Fair Pay Act, which lifts the legal restrictions for people who may have faced pay discrimination. And that in itself is extraordinary because Lilly Ledbetter is from Senator Sessions' home state. She worked in a factory in Alabama for years, and then one day, someone slipped her an anonymous note. What a story. Someone slipped her an anonymous note that said, "You're paid way less than everyone else in this same job." But when Ms. Ledbetter tried to address the pay disparities, she hit a brick wall at every turn. And when she turned to the justice system for help, she found that the laws had statutes of limitations that kept her from getting the pay that she deserved. And the pay she was denied for years and years and years, working side by side with men, doing the same job, and getting paid less in that factory. The Lilly Ledbetter Act changes that. It makes it so that if women find themselves in an ugly, unequal pay structure, just as Ms. Ledbetter did, and we all know people, right? Sisters, wives, children, mothers, who we have a suspicion they're pretty much doing the same thing, especially in a factory setting, especially in a blue-collar setting or in a clerical setting. This is not impossible to decipher whether you have the same job description. Just as Ms. Ledbetter did, they can do something about it. Senator Sessions voted against that law. He also voted against another equal pay bill called the Paycheck Fairness Act, which would go even further and try to close the gender wage gap. On women's health, his record is similarly troubling. He has opposed funding for Title X, which would ensure that low-income women have access to contraception, breast cancer screening, and other health services. He has voted time and time again to defund Planned Parenthood, an organization that provides health care to some of the most underserved women across the country. And finally, Senator Sessions voted against the Violence Against Women Act, not once, but 3 times. Senator Sessions' voting record should concern everyone who cares about fair pay, reproductive rights, access to health care, and access to services or survivors of domestic violence. The last policy area I want to highlight is our environment and climate change. Just 2 years ago, the nominee voted for a resolution that would kill the Clean Power Plan. He also voted for a bill that would deny protections for streams that are the water source for hundreds of millions of Americans. And this is bad news for the world's race to address climate change, which is one of the biggest civil rights battles of our time. And this isn't just a battle against fossil fuels, it's a battle to save the air we breathe and the water that we drink. It's a battle to save the land we live on. It's a battle for the things that we take for granted. And I worry that under an Attorney General Sessions, we're going to have a hard time. That's because even if we really don't have great laws on climate, and we don't yet, they are being rolled back as we speak. And even if Senator Sessions does not push back on those laws, he still has the ability to prioritize certain things over the others. So it's not just his policies that we need to consider, it's also his priorities. Every AG makes decisions about what problems the Justice Department should move to the front of the line. And I've seen lots of reports that leave me wondering if Senator Sessions' priorities might be misguided. The website 538 wrote a piece about Senator Sessions' confirmation process, and I'd like to read a section of it now. Quote, "I care about civil rights," Sessions said. "I care about voting rights." Sessions has cited his record as evidence. In 2009, he said he'd been involved in 20 or 30 desegregation cases as a prosecutor, and this year he told the Judiciary Committee that 4 civil rights cases were among the 10 most important cases he'd worked on in his career. Some committee members were skeptical. Democratic Senator Al Franken of Minnesota said Tuesday that Sessions had overstated his role in the anti-segregation litigation. This is an area where the administration's priorities are clearly going to matter. The number of anti-discrimination and voting rights cases brought by the Justice Department's Civil Rights Division dropped sharply under President George W. Bush compared with his predecessor, Bill Clinton. And the Voting Rights Act recently moved closer to Sessions' personal beliefs. When a 2013 Supreme Court ruling weakened the law, Sessions said it was good news for the South. On Tuesday, Sessions called the act intrusive. So what does this write-up say about what priorities an Attorney General Sessions might choose? Well, to me, it says that voting rights are going to be dealt an already a bigger blow than we've seen in the past few years. And again, we come back to this sense of being extreme. Senator Sessions' priorities, his policy views, they're not in the mainstream for the Justice Department. I don't think that the American people are comfortable with letting politics about policing trump data. I don't think they're comfortable with overlooking our history and our commitment to democracy. So why are we comfortable with this nomination? Final area I want to touch on is Senator Sessions' philosophy. The Washington Post published a news article about a week ago that looks at the executive orders we've seen out of this White House. It's called "Trump's Hardline Actions Have an Intellectual Godfather, Jeff Sessions." And I'd like to read a few excerpts from the article. In jagged black strokes, President Trump's signature was scribbled onto a catalog of executive orders over the past 10 days that translated the hardline promises of his campaign into the policies of his government. The directives bore Trump's name, but another man's fingerprints were also on nearly all of them, Jeff Sessions. The early days of the Trump presidency have rushed a nationalist agenda long on the fringes of American life into action. And Sessions, the quiet Alabaman, who long cultivated those ideas as a Senate backbencher, has become a singular power in this new Washington. Sessions' ideology is driven by a visceral aversion to what he calls soulless globalism, a term used on the extreme right to convey a perceived threat to the United States from free trade, international alliances, and the immigration of non-whites. And despite many reservations among Republicans about that worldview, Sessions, whose 1986 nomination for a federal judgeship was doomed by accusations of racism that he denied is finding little resistance in Congress to his proposed role as Trump's Attorney General. Sessions' nomination is scheduled to be voted on Tuesday by the Senate Judiciary Committee, but his influence in the administration stretches far beyond the Justice Department. From immigration and health care to national security and trade, Sessions is the intellectual godfather of the president's policies. His reach extends throughout the White House, with his aides and allies accelerating the president's most dramatic moves, including the ban on refugees and citizens from 7 mostly Muslim nations that has triggered fear around the globe. The tactician turning Trump's agenda into law is Deputy Chief of Staff Rick Dearborn, Sessions' longtime Chief of Staff in the Senate. The mastermind behind Trump's incendiary brand of populism is Chief Strategist Steve Bannon, who, as chairman of the Breitbart website, promoted Sessions for years. And I quote Bannon, "Throughout the campaign, Sessions has been the most fiercest, most dedicated, and most loyal promoter in Congress of Trump's agenda and has played a critical role as the clearinghouse for policy and philosophy to undergird the implementation of that agenda." Sessions helped devise the president's first week strategy, in which Trump signed a blizzard of executive orders that begin to fulfill his signature campaign promises, although Sessions had advocated for going even faster. The senator lobbied for a shock and awe period of executive action that would rattle Congress. I think we got that. Impress Trump's base. I assume we got that. And catch his critics unaware. I don't know about that, according to the 2 officials involved in the transition planning. Trump opted for a slightly slower pace, these officials said, because he wanted to maximize the news coverage by spreading out his directives over several weeks. Trump makes his own decisions, but Sessions was one of the rare lawmakers who shared his impulses. There are limits to Sessions' influence, however. He has not persuaded Trump, so far at least, to eliminate the Deferred Action for Childhood Arrivals program, under which children brought to the United States illegally are allowed to stay in the country. Sessions became a daily presence at Trump Tower in New York, mapping out the policy agenda and making personnel decisions. Once former New York Mayor Rudy Giuliani was out of consideration for Secretary of State, Trump considered nominating Sessions because he was so trusted by the inner circle, including Kushner, although Sessions' preference was to be Attorney General, according to people familiar with the talks. Since his nomination, Sessions has been careful not to be formally involved, even as his ideas animate the White House. In a statement Sunday, he denied that he has had communications with his former advisors or reviewed the executive orders. And I'm now not quoting from the story. I have no reason to doubt that he established a proper distance once he was the nominee. Sessions has installed close allies throughout the administration. He persuaded Cliff Sims, a friend and advisor, to sell his Alabama media outlet and take a job directing message strategy at the White House. Sessions also influenced the selection of Peter Navarro, an economist and friend with whom he co-authored an op-ed last fall warning against the, quote, rabbit hole of globalism as director of the National Trade Council. John Weaver, a veteran GOP strategist who was a consultant on Sessions' first Senate campaign and is now a Trump critic, said that Sessions is at the pinnacle of power because he shares Trump's 1940s views of fortress America. Quote, "That's something you would find in an Alan Drury novel," Weaver said. Quote, "Unfortunately, there are real consequences to this, which are draconian views on immigration and a view of America that is insular and not an active member of the global community." Inside the White House and within Sessions' alumni network, people have taken to calling the senator Joseph, referring to the Old Testament patriarch who was shunned by his family and sold into slavery as a boy, only to rise through unusual circumstances to become right hand to the Pharaoh and oversee the lands of Egypt. In a 20-year Senate career, Sessions has been isolated in his own party, a dynamic crystallized a decade ago when he split with President George W. Bush and the business community over comprehensive immigration changes. In lonely speeches on the Senate floor, Sessions would chastise the, quote, masters of the universe. He hung on his office wall a picture of He-Man from the popular 1980s comic book series. As he weighed a presidential run, Trump liked what he saw in Sessions, who was tight with the constituencies that Trump was eager to rouse on the right. Sessions was always somebody that we had targeted, said Sam Nunberg, Trump's political advisor at the time. In May of 2015, Nunberg said he reached out to Miller, then an advisor to Sessions, to arrange a phone call between Trump and the senator, and the two hit it off, with Trump telling Nunberg, "That guy is tough." The next month, Trump declared his candidacy. In August of that year, Sessions joined Trump at a mega rally in the senator's hometown of Mobile and donned a Make America Great Again cap. By January 2016, Miller had formally joined the campaign and was traveling daily with the candidate, writing speeches and crafting policies. This Washington Post article offers a look into the nominee's philosophy. Out of the gate, the president has pushed for all punishment and no mercy. The administration has shown a willingness to trample on the rights to satisfy political objectives. And this should trouble everybody on both sides of the aisle who cares about executive overreach. This week, John Yoo, who was the driving force behind enhanced interrogation under the Bush administration, the torture memos, the famous John Yoo from the Office of Legal Counsel, the John Yoo that was demonized by progressives for sort of being the key thinker behind understanding executive power as more expansive than it had ever been understood before. John Yoo, came out saying that he thinks this president has taken executive power too far. John Yoo is saying that, not Sheldon Whitehouse, not the ACLU, John Yoo from George W. Bush's administration. If that's what John Yoo is saying, we should be worried. Think of what the president might do with an attorney general in place who shares his philosophy on immigrants, minority communities, gay Americans, voting rights, and women's rights. The NAACP has pulled together a list of facts about the senator that further fleshes out this philosophy, and it's deeply concerning. In July of 2015, during the confirmation hearing of district court nominee from Maryland, Sessions made the nominee answer for her career as a public defender and civil rights lawyer and invoked Freddie Gray, the teenager unlawfully arrested and killed by the Baltimore police in 2015, as a client inappropriate for a lawyer nominated to the bench. Quote, "Can you assure the police officers in Baltimore and all over Maryland that might be brought before your court that they'll get a fair day in court and that your history would not impact your decision-making?" he asked. And I raise that particularly, he says, because I see your firm as representing Mr. Freddie Gray in that case that's gathered so much attention in Maryland. And there's lots of law enforcement officers throughout the state, and they want to know that they don't have someone who has an agenda to bring to the bench. Can you assure them that you won't bring that to the bench? Quote, in December 2010, Sessions took to the Senate floor to rail against judicial nominees who have what he calls ACLU DNA. ACLU DNA, or the ACLU chromosome. The ACLU, quote, seeks to deny the will of the American people, he said, and has, quote, taken positions far to the left of mainstream America and the ideals and values of the majority that Americans hold dear. In October 2009, Sessions opposed a district court nominee and former ACLU staff attorney by saying, quote, I think we're seeing a common DNA run through the Obama nominees, and that's the ACLU chromosome. And you know, I know people have mixed feelings about the ACLU. Heck, sometimes I have mixed feelings about the ACLU. But remember what happened when this executive order was issued. It was the ACLU that took them to court to protect every American's civil liberties. And they were the ones that won in court right away. And so I say that we need to have special respect for the lawyers who protect our civil liberties. These events should give us all pause, because our country has long associated the groups like the NAACP and the ACLU with the mission of the Justice Department. And now we may have an Attorney General who has, at least in the past, relished opposition to these groups. Before concluding, I just want to say that I understand there may be a distinction between politician, elected official representing a certain state and a certain perspective, Jeff Sessions, Senator Sessions, and Attorney General Sessions. This sometimes does happen as people move from legislative to executive or as they advance in their careers. It is entirely possible, and I sure hope that there will be an evolution, that he understands that he may have his views, or he may have been vigorously advocating for the views of his constituents, but now he has a different role as the chief law enforcement officer for the United States of America, somebody who is there to uphold equal justice for everyone. And so, as critical as I have been of his record, I hope to be proven wrong. And there are people on the other side of the aisle and one Democrat on our side of the aisle whom I respect greatly, who really love Jeff Sessions. And I hope that everything they believe about him and the way he will conduct himself as Attorney General ends up being true. I just don't see any evidence for that yet, other than the word of my colleagues. And that means a lot. But the record is too decisively against all of the things that I care for and all of the things that I believe are important in an Attorney General. I know I'm not alone in having these concerns. Millions of people have signed petitions, made calls, and posted online opposition to this nominee. I've received very thoughtful messages from people in Hawaii about Senator Sessions. I'd like to quote a few of them. I'm writing as a thoughtful voter and human being that Mr. Sessions is not the right man for the job of Attorney General. He may be a friend of the President and his inner circle, but does not represent the values of our democracy. Given his approval of the ban on immigration, I believe he will help the President radicalize and destabilize this country. Another person mentioned the former acting Attorney General, who was fired by the President because she was true to her word when she gave Senator Sessions in her own, because she was true to the word that she gave to Senator Sessions in her own confirmation hearing. Sally Yates told what so many people are thinking, which is, what so many people are thinking, which is, this Muslim ban cannot stand. Another letter from Hawaii. I'm writing to express my most heartfelt disappointment at the direction of our country is taking with the Trump administration. While I accept that those with more conservative views than mine are now in power, I find the actions being taken a gross and crass disregard of our diverse and tolerant national identity. I want to end by making something very clear. We can respect Senator Sessions as a colleague while still believing that his policies, his priorities, and his philosophy are too extreme for the Justice Department. And there are too many issues that this country cares about to confirm him as Attorney General. If you care about criminal justice reform, if you care about seeing fewer people go to jail for petty crimes, if you care about directing fewer taxpayer dollars to the prison industry, then you've got to be opposed to this nomination. If you care about the LGBT community, if you believe that people shouldn't be discriminated against or punished because of who they love, if you believe that people, regardless of their identity, should be able to get married or wear our nation's finest uniform, then you've got to be opposed. If you care about immigration, if you believe in immigration, if you're a business owner who wants to hire the best and the brightest, if your family came to this country to pursue the American dream, if you're a person of faith who believes in caring for those who suffer, for the stranger in our midst, then you've got to be opposed to this nomination. If you care about women's rights, if you believe that women are not to be treated like second-class citizens, that our daughters are just as capable as our sons, and that they have the right to make their own decisions about their own health care, if you believe they should be paid the same for doing the same job, then you've got to be opposed. If you care about our democracy, if you want people to raise their voices and take part in shaping the future of the country, if you are dismayed to know that millions of people are being prevented from voting, not because they aren't eligible, but because of senseless laws that restrict their rights, then you've got to oppose this nomination. The Senate must stand up for civil rights, for voting rights, for women's rights, for immigrants' rights, and that means we must vote no on Jeff Sessions for Attorney General. I urge my colleagues to join me in opposing this nomination. I yield the floor and suggest the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
Mr. President,
Senator from Arkansas.
I ask unanimous consent that the quorum call be eviscerated.
Without objection.
Mr. President, I also ask unanimous consent that the appointment at the desk appear separately in the record as if made by the chair.
Without objection.
I have to admit that this is a bittersweet moment for me. I come here tonight to express my support for Jeff Sessions' nomination to be the next Attorney General of the United States. It's a high honor, and the nominee is more than worthy. But the truth is, I'll be sad to see him go. And all the time I've known Senator Sessions, I found him to be a consummate gentleman. We actually met before I entered the Senate. It was 2013. I was serving in the House of Representatives, a first-term congressman. Senator Sessions, of course, was my elder in both age and rank, yet he reached out to me humbly to discuss a hot topic, immigration. Back then, there was an effort afoot to force through Congress a massive immigration bill the American people clearly did not want. So the two of us worked together to stop it, and I'm glad to say we were successful. But I took away more from that experience than an appreciation of the senator's legislative skills. I got a sense of his character, how he saw the world, what he believed, and why. And if I had to sum it up, I'd say this is a man who loves the law, who spent decades doing all he can to protect it. Senator Sessions knows the law shouldn't be the spider's web of old, which catches the weak but cannot constrain the mighty. It's supposed to uphold the entire community so all Americans can thrive. What we have is a legal system that at its best strives to be a justice system. And I think if you look at Senator Sessions' career, you can see the same qualities represented by the balance, the blindfold, and the sword of Lady Justice. First, like the balance, he has a judicious mind, honed over his 12 years as a U.S. Attorney and his 2 years as Attorney General of the state of Alabama. He evaluates the evidence carefully and comes to a well-considered conclusion. I'd argue it's this very approach that led him to advocate for an immigration system that works for working Americans. And I have every confidence, as our top law enforcement officer, he'll keep the interests of American citizens uppermost in his mind. Second, like the blindfold, he's impartial and fair-minded. I think of the fair sentencing law he passed with bipartisan support to bring harsh penalties that fell disproportionately on African Americans more in line with the kinds of penalties that fell on other criminals. I also think of his work on behalf of a more equitable distribution of funding for HIV/AIDS patients. Just as Senator Sessions strove to represent the interest of all Alabamans, I think Attorney General Sessions will strive to uphold the rights of all Americans. And third, like the sword, Senator Sessions believes in swift and strong enforcement. Perhaps the best argument for his candidacy is the extensive list of endorsements he's received. The Fraternal Order of Police, the National Sheriff's Association, the Federal Law Enforcement Officers Association, and the list goes on. I would think such widespread support among the people whom he would oversee would make a deep impression on any senator's mind. If the people who actually enforce the law believe in his leadership, then so do I. And so, I'm sorry to see him say goodbye to this august body, but I'm confident he'll serve the American people well. He's the right man for the job, and I urge all senators to vote for his confirmation. Thank you. Mr. President, I yield the floor.
The clerk will call the roll.
Mr. Alexander.
All right, everyone. Thank you very much for joining us today. This is our conclusion. We're going to start streaming later on today at 6 a.m. It's actually almost tomorrow, but we're going to start again at 6 a.m. Pacific, 9 a.m. Eastern. So make sure that you join us. Jeff Sessions' vote is set to start around 9 a.m., but we'll start our coverage at 6 a.m. Don't forget, here on Golden State Times, make sure that you click that thumbs up and you subscribe to the channel if you're new. If you already joined the community, we welcome you, and click the little bell so you can get a heads up on when we go live again. Thank you very much for joining us one more time. And I hope that you guys join us later on today. There's going to be a White House presser today. Jeff Sessions' vote today. There's going to be a bunch of stuff going on. So if you can join us, we encourage that you do. Thank you very much, everyone. Have a good night, good morning, good evening, wherever you're at. And I hope to see you guys here tomorrow. If you'd like to help out the channel, there's a few ways of doing it. Sharing our streams, our videos, everything is always appreciated. It helps us immensely. We are selling a mug, a coffee mug. If you would like to check it out and order it, it will be in the description below. It helps out the channel. It helps us continue operations. And we encourage people to check it out. And if you want to order it, we thank you very much in advance. If you just want to contribute $1, whatever, our link to our PayPal is also below. Follow us on social media. We always put up all breaking news and all that other stuff on there, so make sure you follow us. We're on Twitter, Facebook, Gab.ai, all that good stuff. So thank you very much, everyone. See you guys later. Good night, everyone.